admission column, reply not filed also. On Monday next slide. It was last listed in the month of like
Yeah, please, Your Lordship. I beg to mention for listening to repetition, Lordship, in admission column. Right, Lordship. Let it be in June. Lordship, what is the matter? Lordship, petitioner. 1st of June. Yes. 1st of June.
May Lordship, my lord, with your consent and other side, I'd like to mention item 18, my lord.
18.
My lord.
1-8.
Yes, my lord. The conducting council NJ Gatman is out of station. I pray for adjournment.
Item 18.
My lord, please.
Item 18. The request made on behalf of the arguing council hearing for the petition of matter stands referred to be listed after 3 weeks.
After a week.
After 2 weeks.
Of life. Wait, your lordship. Lordship, I'd like to mention listing of a petition for orders, lordship. Next week, any day, lordship.
25th.
Your lordship, with your consent of your other side, I'd like to mention item number 14 to kindly pass over for the lordship.
14.
Yes, lordship.
14 is item number 26 also connected with this. There is same issue, lordship, territorial jurisdiction.
14 and 26.
26.
26 who's appearing?
MJ Borwa, I have informed him.
Uh, 14 and 26 stands deferred to be listed again after 2 weeks. Party.
with the consent of the other side, I would like to mention item number 10 and 11 also. The matter may kindly pass over for the day also.
10 and 11 and the request made on behalf of the petitioner.
Yes, Lord. And for the
Matter stands passed over to be listed after a week.
But we kindly fix a date.
It is already fixed. Why you agree to adjournments if you want a fixed date? Why are you agreeing for adjournment? Let it come after 30.
much of that.
Mr. Lordship, I'd like to mention for item number 7, Lordship, with the consent of the other side. We're going to file affidavit to the Lordship.
Yes. They are going to file affidavit today. Can you record it? Post it after 2 weeks. MS so-and-so appears on behalf of PWD department, submits that the affidavit will be filed during the course of the day. Stop Mr. H.K. Sharma, counsel appearing for the petitioner, submits the matter, then therefore be posted after 2 weeks, by which time they may be permitted to file their rejoinder report. They may disallow list after 2 weeks. Fix a date. Date for employee removal from fund. 18th June.
Yeah, please. Lordship, I'd like to mention for listing my 22 meter.
Huh?
22 meter.
22 matter. 1st of June.
May I please, your lordship, I would like to mention WPC 223. It was earlier sent for mediation and it was concluded successfully.
1st of June.
Lordship, I'd like to mention item number 20, Lordship. I have taken the consent from other side.
You have taken
Yes, Lordship.
item 20 on the request of the counsel for the petitioner stands deferred. Be listed after. Here.
I'd like to mention item number 25. This honorable court earlier considering the urgency, upgrade the matter.
Second half. Second half.
Okay. I'm not chilling the inquiry reports, so I want to go in the
In view of the instructions received, the counsel appearing for the petition that wish to proceed with the matter any further, the Writ petition stands dismissed. With liberty. Interim order is then stands vacated pending either or.
Close to.
The interim order, there is will be disobedient, my lord. So, my lord, may kindly come to page 20, my lord. It's an order, my lord. Which is in first verbatim, my lord, the petitioner was directed to give the provisional pension and other pension may benefit, my lord.
So what is wrong with the, we'll call up the writ petition. Why is the writ petition? Who's appearing for the other side?
My lord, Mr. Nayak, my lord, additional advocate general is appearing for the department, my lord.
Hmm.
My lord,
What has happened to the, what interim order?
my lord, may kindly come to page 20, my lord. Page 20 of the content. The petitioner, my lord, actually he retired in July 2022, my lord.
When is this matter required to be listed?
My lord, it was, my lord, directed to be listed on today, my lord.
No, this writ petition, otherwise.
Otherwise, my
Last,
lord, it was fixed today, my lord. So this content case on last occasion has been listed along with this writ petition.
okay. So,
I am sorry, Lordship, in this case, I am not there. My colleague is there.
who colleague?
Council P. Nayak.
P. Nayak is appearing, my lord.
Oh,
And Mr. R.K. Talukdar, my lord, he is appearing for the response number 9, my lord. He is an AG, my lord.
where is Mr. Nayak?
Lordship will take after something.
We'll call up later.
Lordship.
Yes.
Please, my lord. My lord, we have filed our affidavit, but it has not been placed in record because yesterday evening we came to know there was a defect. So the matter may come up on 28th. We pray for 28th or 1st of May.
Affidavit means reply, rejoinder.
Yes, it's rejoinder.
Counsel for the petitioner submits that rejoinder affidavit has been filed. However, since it was filed yesterday, you filed it yesterday.
Yes, ma'am.
The same is not connected to the case report. So it's free to trace out the affidavit. Rejoinder affidavit stated to have been filed by the petitioner and list this matter after 1 week.
My lord, maybe a date, it's 28th or 1st of anything. Among the
11 June. 11.
11th, my lord, then 13th, senior.
No, don't haggle. You either accept a date or it comes after 1 week. What is this? You are asking for dates. We have given you a date. You asked for a date. We have given you a date. You know the matter is fixed today. Why did you file it yesterday? Why not earlier? Roster is not fixed as per the council, as per the requirement of the court. Yes, we accommodate council. It's not that. 11th. Mr. Borgwai,
H.
appears for the
For the
SBI.
SBI.
Mr. H. Das
It's that's for private respondent.
for private response.
6 and 7.
6 and 7.
But
They are supposed to. Lordship, I appear for respect number 1. As per instruction, they could not complete the process because of the model code of conduct was in place. They praying for some more time, Lordship.
What is to be conducted?
Lordship, there's a select list published which was not given a logical end because they have issued a notice to cancel, which Honorable Court says no. Give them the posting, Lordship. As per the select list. Page 31. There are 12. It's a recruitment process which was initiated, but halfway they wanted to cancel, which has been,
Set aside.
yes, Lordship.
Set aside and,
Directed to
Mr. M. Khan for the petitioner, Mr. D. Dekar. APS for the respondent number
1.
1. He submits that you have filed your affidavit.
No, Lordship, we'll file for the instruction, which says that they will carry out.
Submits that he renews his prayer for further time to file the affidavit. List accordingly. After 2 weeks. Then June.
Like that.
Here in item number 5,
Yes.
yes, I'm appearing on behalf of Mr. Abha Pujari Lordship. Here, I do not have the complete instruction, but the case of the petitioner is the person was given certain payments under the new pension scheme. Now they are asking for the benefits of the old pension scheme. So, as per my instruction, Lordship, the department has not considered Lordship, but they have accepted the fact that he should be governed by the old pension schemes. Now, a policy decision has to be taken, Lordship, because for the people who have already been granted the benefits of new pension scheme, how they are to be bought into the old pension scheme, because Lordship, there has been certain contribution from the government also, from the petitioner side also. If he wanted the benefits under the new pension scheme,
Where is the decision of the government that
Lordship, that decision, Lordship, I have been told, like the instructions are with me, Mr. Abha Pujari, Lordship, I have been told that it will require at least 3 weeks time for that policy decision to take place, Lordship.
no. Where is the decision of the department that he is entitled for the earlier?
Lordship, that I have been given these oral instructions, maybe perhaps the original decision might be with
Where is Mr. Borpuzari?
Lordship, he is out. Lordship, he said he's coming to the court maybe at 2. Lordship fixes the matter at 2. Maybe he'll be in a.
Is it convenient for you at 2 p.m.?
Yes, no, it is okay. I'll be waiting. My lord, I may be a small submission because it is a settled case through mediation. I am in the old pension scheme, but I am asking for my own contribution under NPS. This is the deduction from my salary. And it is a settled case.
You want to go for mediation.
My lord.
You want to prefer mediation. Settle it.
No, mediation, it is settled case in mediation. It is settled in mediation. They're supposed to pay me my contribution that has been deducted for NPS. I'm getting pension under the old scheme, but erroneously they have deducted my NPS for a long period from 2008 to 2019.
Mediation before the court, before the High Court Mediation Center.
My lord.
Where is that mediation report? Not here.
Mediation report they must have submitted because it was settled in the October, last of October 2015.
Not here.
All the parties, they have agreed.
Do you have a copy of the mediation settlement report?
I don't have. I have not been given a copy. Number of days where they are telling, they are asking from my learned respondent, yes, his NPS, his deduction from his salary, it will be paid. On
yes, Lordship.
Date after date, only nothing, this old scheme, nothing. Since he's getting pension under the old scheme, 1969 scheme, and this is his own contribution from his salary, NPS.
Mr. Upadhyay, what is the outcome of the mediation?
Yes, for my understanding, Lordship, the case is, Lordship, he has contributed in the NPS.
What happened before the mediation?
That instruction.
It was referred to mediation on 26/8.
I take from my time.
You don't have a copy, nothing. No report. Then we'll have to ask the registry to inquire and give us.
My lord, I'll put.
In terms of the order dated 26/8/25, the matter was referred for mediation. Subsequent orders passed by the courts, by the court, does not reflect as to the outcome of the mediation. So, there are today when the matter is called up, counsel for the petitioner submits that okay, no, it is here. It is here. You have already agreed for release.
Yes, Lordship, here now the only obstacle is there were certain contributions made. Now, how to revert back that contribution?
Then why did you agree if you don't have a scheme? You have agreed before the mediation that you'll release the amount.
Yes, Lordship, that some pension is getting the old pension, Lordship, but only now I think the issue is the contribution that he has made under the NPS. Yes. That has to be refunded, Lordship. He is already getting the pension, Lordship. Now only the refund part is there.
What pension here, my lord, he's getting the pension that is under nothing. But this is his own contribution, deducted from salary, his own money.
You have agreed in the mediation, so why should we go any further? You have already agreed everything. Then we'll close it in terms of the mediation order, settlement. Have you gone through the mediation settlement order? No.
No, I'm not.
Please go through it. Please go through it. All the counsel from both sides go through it. You have both agreed that this will be released.
Yes.
How the formality is to be worked out, you work it out.
Yes, Lordship. That is, we are working on that only, Lordship.
So working on that can't take eternity.
No, Lordship. The department is asking for 3 weeks time, Lordship. Right? Refund the amount. Otherwise, pension is getting.
Please go through it and we'll call up again in a while.
Items 1 and 2.
Yes, Mr. Nair.
Lordship, this matter pertains to finalization of pension, Lordship. In the meantime, Honorable Court directed for release of provisional pension and other retirement benefits, Lordship. That has not been yet, been released. Lordship.
Why is it not released?
Lordship, that instruction I am looking for, Lordship. They are not furnishing any instruction, irrigation department. In the meantime, they have filed one contempt case, Lordship. May issue notice in that contempt case, Lordship, in the meantime. Whatever instruction.
We thought the notice may not be required if you give the assurance that you are going to do it within a fixed period of time, because this is a pending matter.
Yes, no.
This is contempt is against an interim order.
Yes, no.
Then
Lordship, in that situation, Lordship will take up this matter after 1 week, Lordship. I will have some concrete instruction without issuing notice in the contempt case.
My lord, in the page 29, my lord, the executive has written, my lord, that he is not in a position to process his retirement and other legal benefits. Even on, my lord,
the
22.
pleadings are exchanged here.
Yes, my lord.
Affidavits filed.
Yes, my lord.
Fine.
Mr. G. Alom, Learned Counsel appears for the petitioner, Mr. P. Nayak, additional AG for the state. So, by order dated. Which is that order? 7-8.
Yes, my lord. The previous order, my lord, 7-8, my lord. 7-8 and subsequent another order, my lord,
7-8-2025.
and 13-3-26. Page 20.
Was a direction for release of even
Page 20.
provisional pension. With effect from 1/8/2022. And also his DCRG, dues in respect of DCRG, leave encashment and other pensionary benefits. Stop. This order was reiterated subsequently by order dated 13/3.
Yes, my lord. Page 26.
13/3/2026. So, in spite of two orders passed by the court, the directions have not been complied with, and therefore the contempt petition has been filed. Today, when the matter is called up, Mr. P. Nayak, additional AG, submits that he be permitted 2 weeks' time
Yes, lord.
to complete his instructions in respect of the directions issued by the court and apprise the court thereafter. List the contempt petition along with the writ petition again after 2 weeks.
Obliged, my lord.
Mr. R.K. Talukdar for Accountant General.
Your Lordship, my learned friend is having some personal difficulty while coming. Kindly pass over the matter for
Who is your learned friend?
Standing Counsel for Forest D. Gogoi. He is coming, Your Lordship. Kindly pass over the matter.
So now we'll have to wait for standing counsel. There is another standing counsel, Mr. Bothakur. Where is he?
My lord, they are taking time one after another, my lord, in the name of my lord obtaining instruction, my lord. But there is, my lord, admitted amount, my lord. And my lord, way back in.
There is Mr. Bothakur.
I'm here for D. Gogoi for standing for it.
You call up. You inform Mr. D. Gogoi to inform his colleagues to be present here. He'll call up in 10 minutes. Yes.
I think we.
Please, proceed. Pursuant to the order dated 8/4/2026, I have taken already justice service upon the respondents. On that day, interim notice was also issued on the pair of interim release also.
Your Lordship, I appear for respondent 225. Will file our affidavit in opposition. I have entered appearance today.
Oh, this is what for challenging an order
Yes.
of the labor court.
Not the labor code, the termination of a contractual employee in the web course.
What is web course?
Is Water and Power Consultancy Service India Limited.
Public sector undertaking.
Yes, yes. This is under the Government of India.
Ministry of Jal Shakti. Whatever logic during contractual period, the petitioner is terminated by serving first he has served with a notice of discontinuance of service, thereafter he terminated. And agreed by both the notice issued to the upon the petitioner. If nice selling. And interim his relief has been paid
What
to
is your,
remain-
what is the interim period?
to remaining him at least during contextual term on September 2025, 26. That contextual term will be finished in the Lordship page number
No, but
14.
interim
Annex
relief
2.
will ultimately give you the final relief.
This is only. Thereafter, if I will be terminated, then I will go.
Why were you terminated?
No, there. Not had been mentioned, only served in notice. That
Where is your appointment order?
appointment order is at page number 13. Every 2020, 2014.
Where is the agreement?
Agreement is page 14. Paragraph 2. Paragraph 1.
Page 14.
Page 14. Paragraph 1. The service of to the watchman.
No, this is not agreement.
And this is the
No. You come below, you'll find. There's some. You have to submit a contract agreement and non-judicial stamp paper.
it is submitted before the.
You don't have a copy.
I have no. Lordship, in Delhi High Court, in similar situations, persons.
Your
have,
lordship may
got
kindly
interim
come to
relief.
page 15 of the writ petition for
Hmm?
once.
Hmm?
Page 15 of the writ petition, the notice of discontinuance.
That we have seen.
There I
There
think,
it refers to a contract.
yes, one clause number 7 of the
So where is
agreement.
that contract?
So I don't think that has been annexed. We'll annex it along with the affidavit.
What happened in Delhi High Court?
Delhi High Court has given some interim relief in similar situated person. They state the notice for on at least this contextual term only. That's last one. You have to wear it.
This is in respect of extension. Your case is not extension.
This is respect of first notice. prior to
You read
termination.
para 4 of the judgment.
No, it is. But as well as the challenge of notice,
When were you disengaged?
I was disengaged on February.
Page 16, Your Honor.
What is the
February
position?
20.
What is the position there? Have you engaged somebody in his place?
No. Because as per my instruction, there is a contractual post and the company is saying that there are a number of permanent employees already working as watchmen. So under those circumstances, his engagement, contractual engagement is not necessary. And there are no other contractual watchmen who has been engaged in his place as per the instructions.
But you had approved him from July 14th. July 14th, page number 13.
Page 13. Yes, earlier also we had engaged him. Then again, like it was renewed from time to time. From July 14 till I think for a period of years. Then again in the year of 2017 also we have engaged. That kind of contractual agreement were there between the company and them.
But counsel for parties, this petition is filed by the petitioner who is putting a challenge to the termination notice issued. Notice of discontinuance dated 3001/2026. So petitioner was engaged as a watchman under the respondent corporation with effect from 1st of July 2014. Stop. He continued to render his services and his period of engagement was extended from time to time. Stop. The last extension was issued on 1/10/2025 to 3009/2026. So, while he was rendering his services, the impure notice of discontinuance dated 3001/2026 was issued, discontinuing the services of the petitioner, contractual engagement of the petitioner as a watchman with effect from 28/02/2026. Stop. General has approached this court, acceding the said discontinuance order on the ground that the same is violative of the terms of the contract and also he was engaged for his period was extended from the period 1/10/2025 to 3009/2026 on the existing salary allowances and chargeable head, along with the terms and conditions therein. Stop. It is submitted that there is no specific reason cited as to why the services of the petitioner should be dispensed with. There is no finding that there was any shortfall or deficiency in the services rendered by the petitioner. Stop the extension period of the petitioner was duly extended by execution of an agreement by and between the petitioner and the respondent authorities. So, under such circumstances, it is submitted that petitioner should be allowed to work for the currency of the contract period and not be terminated at this stage. Stop. Mr. S. Dr. and counsel appears for the respondent number 225. MS. Each of A Gayan for union. Respondent number 1. So. The respondent counsel submit that their instructions are not complete. They would like to complete their instructions and pray for how much time? 2 weeks?
3 weeks.
3 weeks time. They are considering the submissions made and on perusal of the pleadings. This court had earlier issued notice on 8/4/2026 and permitting the petitioner to take service by way of dusting on respondents 2 to 5 and also issued a notice prayer for interim relief. Stop. Since the respondents are represented and from the materials available before this court, it is seen that the petitioner's contractual term was extended from 1/10/25 to 30/09/2026, and also that the petitioner has been rendering his services with effect from 1st of July 2014. And in the notice of discontinuance, there is no finding that there was deficiency in service in respect of the petitioner, this court is inclined to grant an interim relief in the next returnable date. The impugned discontinuance notice shall not be given effect to. The petitioner will be permitted to render his services on the existing terms and conditions and allowances till the next returnable date. Depending on the instructions that may be placed before the court, the continuance of the interim order will be reconsidered on the next returnable date based on 15th July.
Of the plan.
Pending item number 3.
Yes.
Well, his claim is under examination and DFO Dhubri has been asked to submit some documents because he has to submit a document of the concerned circle officer that he has earlier no payment and no claim was submitted.
What is his claim?
Well, he's asking medical reimbursement. He got treatment in a private hospital, but rules contemplate he has to go for government institutions. They are even after that also we have.
No, but there are where the government hospital is not available or does not have the treatment. Is entitled.
So, that is under verification. A concerned circle officer has to submit a no claim certificate.
What relation has the circle officer got to do with it?
Rules are there, the medical reimbursement rules.
As we speak, my lord, that report is under preparation.
Circle officer.
No, my lord, the DFO is doing the exercise, my lord, the concern, the requisite exercise, and he's preparing a report. It will be forwarded very soon.
This case, my lord, expecto, as prospecto approval was granted, my lord, in the year, my lord, 2021, my lord.
Do you have the rules?
Right now, I don't remember, my lord. Just send to the
Already,
medical
my lord,
board, my lord.
my bank account also, my lord, my lord.
What does the rule say in respect of these certificates to be issued?
Will receive requirements.
What does the rule say? You are employed under the forest department.
Yes, my lord. And he has to give reasons for taking treatment in a non-referral hospital. And yes, madam, he has to. And let the report come, madam, it will be clear, madam.
So what report are you asking for? No, earlier no payment. How will the circle officer know? I can understand you are asking for a report from the treasury office.
My lord.
Circle officer, how will he know whether any payment is received or not? Will
Well,
go through him.
My lord, we have issue, I tried to clarify with the respondents. They say, my lord, that very issue that he has to go for government hospital to government hospital because he took treatment in a private hospital, my lord.
All right,
That
but
is
you are
causing all
asking
the-
for a report from the circle officer. What report? Yes, Mr. Counsel, for the petitioner.
My lord,
Enlighten us.
already, my lord, required documents and required particulars I have already.
What
been
required
submitted.
under what rules, what provisions?
My lord, that which mail I have to, my lord.
You are alleging deficiency in service and coming to the court asking for a writ. And you do not know under what provision you are entitled, under what provision your entitlement has not been
My
issued.
lord, please, there, my lord, I have to, my lord.
Counsel for the petitioner will apprise the court in respect of the rules under which he claims have been made. Meanwhile, Mr. D. Gogoi, standing counsel Forest,
My lord.
will also apprise the court with regard to the steps taken by the respondents
My lord.
towards the claim of medical reimbursement, at least after
Short
3
that may
weeks.
be given, my lord. Short that may be given.
No date. After 3 weeks, once you have the rules, you understand, you make a mention, we'll fix a date. All right?
Then, my lord, 2 weeks, my lord.
2 weeks.
Oh.
All right, madam.
Please, your lordship. But in this case, your lordship wanted us to have the instruction as to what has happened after passing interim order, whether the private respondent is still continuing. He's not continuing when some order was passed, discontinuing services. So,
Who is not continuing?
private respondent.
Oh.
There was some interim order passed on 10/9/2025, by which your lordships had stayed the impugned order of appointment of Gauhati.
On what basis are you saying that any communication to the receipt? Yes. He's been asked to, his order has been cancelled. Private respondent. Anyone representing the private respondent? Yes.
My lord, on last occasion here, my lord. Took time.
In reference to the earlier order dated 12/5/2026, the Learned Standing Council, NC Hills Autonomous Council, MSP Chakrabarti, has obtained her instructions and placed before the court the order dated 15/9/2025, which was issued by the NC Hills Autonomous Council, Haflong, the Mahasau District Settlement and Revenue Department, whereby the appointment order dated 14/8/25 appointing the private respondent number
Fine.
3 was appointed as a Gaumura of Prasadimik village stood cancelled. So the private respondent, by the said order, the private respondent was directed to refrain and was relieved from all duties and charges as a Gaumura of the Prasadimik village. Stop. Copy of this order is placed before the court by the Learned Standing Council, and the same is kept on records. The respondents submit that their instructions are complete and would like to find their counter affidavits. Respondent number 3. The Mahasau Council has already filed their affidavit, which a rejoinder affidavit is already filed. So, considering that the prayer made on behalf of the respondent number 3, relist this matter after 3 weeks.
Interim order,
The interim order passed earlier, if any, will continue.
like,
Chief, we've already filed our affidavit, Chief. We've already filed our affidavit, Chief.
Your file.
May let the matter come up for hearing on the next day, Chief.
Any rejoinder to be filed?
no, my lord, I already admitted, my lord, stating that, my lord, matter referred to the government, my lord.
Then
But, he has not denied that regarding pension. Respondent number 4 filed affidavit.
which paragraph?
Paragraph, my lord, 6, my lord. That with regards to statement made in the answer is upon the exposed that the incumbent died prior to regulation of the service. The proposal for was submitted to the higher authority for regulation of his services.
How many years have you put in?
My lord, the husband died.
Your claim is for
Family-
pension,
Family benefit.
family pension.
Family benefit.
But he was not regularized.
already regularized, my lord.
Huh?
But expired, my lord. Regularized, my lord.
Then why is it sent for regularization of his services?
My lord, kindly see, my lord, page number 17, my lord, regulation order.
Lordship, Mr. Arthur is on next, Lordship, so
Call him,
he's on next, Lordship.
please call him.
Lordship, you can take maybe after some time.
Yeah, we will, you call him in the meantime.
Lordship,
yes.
he's on next now. I'll call him
Yes.
after some time, Lordship.
You call him. We permit you to go and call him. Yes, what is this in page 17?
Page 17, my lord, is a regulation order, my lord. The type copy and original copy, kindly see, my lord, page 22, my lord. Serial number 158. The husband of the petitioner named my lord Viren Patgiri expired and date of joining 1/4/1992. Is the regulation order, my lord, passed on 18/10/2005.
Where is the regularization order?
Page 17, my lord, regulation order.
17. But how can the executive engineer regularize? Does he have the power to regularize?
My lord, as per my lord guidelines, my lord, government notification, my lord, published on my lord 22nd August 2005. It was clearly stated, my lord, paragraph number 3. So the finance department at that point of time modified to regulation. And see, my lord, page 3, my lord. Paragraph 3, my lord. Point number 3, my lord.
Page 3.
Page 3, my lord. Point number 3, my lord. For regulation of 6 number of workers and 42 numbers of masterhood workers in PWD, 1 number of masterhood workers in water resource department, and 12 numbers of masterhood workers in handloom, textile, and sericulture department who had been engaged prior to 1/4/1993 and had either attained the age of superannuation or expired. After rendering continuous service, the respective administrative department will create supernumerary post to appropriate grade in respect of worker or grade 4 in respect of masterhood worker for 1 day only immediately preceding the date of superannuation /death, as the case may be. In paragraph point number 4, in respect of workers of masterhood workers who had already expired, orders regulating their service will be issued by the respective appointing authorities on obtaining death certificate from the competent authority. And PWD department, kindly see my lord, page number 2, my lord, of that, my lord, public work department, my lord. My lord, public work department total post, my lord, kindly see in the last, my lord, 19, who has expired, already expired. Post already, my lord, sanctioned, my lord.
Which page?
Page 2, my lord. It is a list, my lord. Well stated, my lord. The public work department. Some of the person, my lord, retired prior to regulation and some of expired.
No, you are referring to page 3.
3, my lord.
Clause 3.
Clause 3.
Clause 3, they are supposed to create supernumerary posts.
Post, my lord.
Only after that, the question of regularization or appointment will come in.
But the regulation order, my lord, they are.
How is the executive engineer empowered to pass regularization order? Under what provision?
But reflected in the serial number 158, my lord.
Yes,
So. Just.
he's on legs, so what can be done? You get instructions,
After it's done.
huh?
He'll come right after it's done.
After he's finished, all right. We'll call up again, Mr. Patni. Wait for him. All right, please inform him. Come after he's done. Yes.
This matter, perhaps I'll seek some accommodation. No need. But apparently, what I feel like, this petitioner has been given the benefits on paper. The actual benefits accrues to him has not been converted to financially financial input. So Lordship will fix this matter, though we have filed the affidavit in opposition, but further more clarification is required. Lordship will highly adjourn this
What
matter.
are your prayers here?
Page 11. Actually, I was given promotion with retrospective effect. Supernumerary posts were created and financial benefits were granted after the finance concurrence and all. Now they did not release the financial benefits. Accordingly, we had come to this honorable court. During the period from the AG, a clarification was raised that so far as the supernumerary creation posts were concerned, there were two periods, A to B and C to D. The interregnum period, or that used term betwixt period, B to C, is not explained by the department concerned. On this point, the entire matter is halted. So my friend would get the instructions from that because they are not denying the fact that it was granted, notification was issued, but only release was halted. That's all.
I'll seek some instructions next week.
Mr. S. Bonik for the petitioner, Mr. B. Gogoi for the forest. Mr. Gogoi submits that the claims made in the petition have been accepted by the department and consequential orders have been issued. However, the status of the conferment of the benefits pursuant to these orders is awaited. State instructions to respect of the status of conferment of this benefit pursuant to the orders is awaited. Praise for 2 weeks for the time. We get this matter again after 2 weeks.
Public.
Wait.
For the petitioner, my application allocation is there.
What seems to be the objection here?
Their contention is that the dispute, should there for to be referred before the arbitrator, that those are not arbitrable, but that has to be decided by the learned arbitrator himself.
Where is that clause
Yes, ma'am.
for arbitration?
Your lordship kindly comes, kindly allow me. Our arbitration clause is at page 121.
Yes. It has to be referred to dispute resolution first.
First, if your lordship kindly sees clause 63.1 first. That is mitigation of dispute. That was done. They have disputed my allegations, my lord. Now, my lord, they have suggested me
that if you want to address those disputes anymore, go for arbitration if those are arbitrable in nature. If your lordship kindly sees on the page 324. Before that, on the page 323 once. 323. Under that notice, they have replied to my notice for mitigation of dispute. If your lordship kindly comes to the notice after dear sir, my lord, in reference to your above, I'm sorry,
Page number 323.
323.
Yes. Yes.
May I?
Yes.
In reference to your above referred letter, please enclose here with a copy of the comments furnished by so-and-so in connection with the dispute arising out of so-and-so dated so-and-so. If you still consider that the issues require consideration for appointment of the arbitral tribunal, specific claim may be submitted for further consideration. It may be noted that the claim should not fall under the accepted mention in GCC clause number 63.1. So, my lord, they are relying that you can go for arbitration, but those points of disputes has to be arbitrable in nature, not under the accepted matters. So, my lord, my contention is that the existence of the arbitration clause in the agreement is not disputed. My lord, so far this referral court is concerned, that court will look into whether there is a existence of arbitration agreement or not. Now, whatever else, that will be decided by the learned advocate. Now, that is the case before your lordship, that those are not arbitrary.
No, what are not arbitrable? That's what we are trying to find out.
If your lordship kindly comes to page 8 of my application, those are the dispute I have raised.
No, in terms of the agreement, is there a distinction between?
There is no such distinction. We are only mentioning which are not accepted matters, but which are.
What is accepted? Where is it defined?
My lord, kindly comes page. Yes, my lord, page 119, my lord. Thank you.
Yes. 119.
Yes. My lord, kindly sees, my lord, starting clause 59 onwards.
$59.9.
It is 59.9. I'm so sorry. 59.9 onwards.
What is this? Is an extract or
Extract of the GCC. It is reproduced here. Extract of the GCC reproduced here.
no? Because if you look at page 119, it begins with 7.3
Yes.
and then clause 16.
If your lordship kindly comes to page 117 once. 117, my lord, clause 6.0 at the bottom. Settlement of dispute, Indian Railway arbitration rules. Arbitration and settlement dispute shall
Be governed by 63-64.
yes of the Indian Railway Standard General Conditions of the Contract 2018.
So where are these conditions?
Well, this is reproduced here.
It
Kindly
is
come to next.
63, page number 121.
Yes, ma'am. They have mentioned those clauses in this agreement, my lord. And they have mentioned also that this is reproduced here below, subject to any correction made prior to the opening of this tender, which is there at page 118.
All right. So you issued a notice not replied.
notice replied, although my instruction is that they have not received, but from the affidavit in opposition, I can see that they have replied. Assuming that they have replied. On the same matter, they are saying that those disputes you have raised are under the accepted matters, so that cannot be arbitrable in nature. But that has to be decided.
Where are the accepted matters? Is it defined?
It is not due that I could not find it from the agreement.
It is there in the GCC, my lord. The GCC, perhaps it has not been annexed. It is there in the general conditions of contract.
What is this? This voluminous document?
No, that is the contract, my lord itself. The contract.
It does not contain GCC.
It does not contain GCC.
No, but I have not annexed the GCC, my lord. So they have produced the arbitration mechanism from the GCC in their in this agreement, my lord. That is why that was not produced.
But my lord, the issue is not this, my lord. The issue basically here is, my lord, that the pre-arbitral process is there, my lord, provided in the contract agreement. That pre-arbitral process, my lord, has not been followed by the contractor, my lord. He has made a representation.
What is the pre-arbitral process?
That is page 121, my lord, under clause 63.
Dispute resolution.
Yes. Page 121, clause 63.1, my lord. First, my lord, the contractor has to make a representation before the general manager regarding the disputes. My lord, that representation the petitioner had made, and thereafter, my lord, at page 323, the railways have replied, my lord, by stating that kindly make specific claim item wise. So that, my lord, if my lord can take page 323.
323.
323, my lord. Paragraph 2, my lord, is stated, if still you consider that the issues require consideration for appointment of arbitral tribunal, specific claim may be submitted for further consideration. It may be noted that the claim should not fall under the accepted matter mentioned in GCC clause 63.1. Moreover, as per clause GCC 64.1.2, you are requested to submit the claim submit amount of claim item wise. Now, my lord, coming to the
Well, that is so far departmental
letter dated
arbitration is
112,
concerned.
but as to whether the claim, whether any specific claim has been made or not, my lord, that is at page 319.
So all these can be looked into by the arbitrator to decide. You raise all these objections
No, my lord,
for the arbitrator.
But the pre-arbitral process, which requires that a specific claim has to be made to the general manager, and then the general manager will accordingly, my lord, decide. That decision under 63 has not been made, because clause 63 and 64, my lord, there are two clauses. 63 deals with the pre-arbitral process, which, my lord, provides for making a representation before the general manager. Once that representation is decided in negative, my lord, or in favor of the contractor, if he still agreed, my lord, then comes clause 64. Here, my lord, that stage has not crossed.
The 1 minute. Yes.
If my lord takes page 319, my lord, which is a notice under clause 63, before making a specific demand under section 21, as per clause 64, that is the notice, my lord, at page 319. If my lord reads that notice, my lord, there is no specific claim mentioned there. There is no amount of claim, quantum, nothing is specified. And as lordship already knows, my lord, in clause 60, as per clause 64, my lord,
the quantum has to be decided, my lord, in order to determine, my lord, whether the matter will refer to the single arbitrator or three arbitrators. My lord has already decided similar issues. So, my lord, in absence of any specific claim and quantifying, my lord, what is the amount of claim? My lord,
What is LD?
LD is liquidated damages.
Liquidated.
That the railway has imposed, my lord. The dispute has arisen out of that. But, my lord, the specific claim has to be made, my lord,
That is his claim, LD. Your claim is with regard to what?
Liquidated damages, releasing of bank guarantee, and my lord,
there are other disputes also, my lord.
other disputes those are mentioned in paragraph 9 of my application, my lord. And my lord, so far my learned friend is
So
referred.
these are issues which can always be looked into. I mean, is it a case that there is no dispute at all? You have released this amount as per their dues, etc.
There is a
Nothing like that.
dispute, my lord, but our contention is that specific claim should be made so that the general
So
manager.
once there is a dispute, you have to resolve it. You can resolve it now if you undertake that, yes, we will departmentally have a look and we'll sort out the disputes. We'll give you liberty to do it.
Lord, we replied, my lord, by saying that, my lord, kindly make the claim claim wise, my lord, the amount
that
of the
was
claim
refused.
item wise.
My
That
claim was
they have
refused, my
not
lord.
made thereafter. It was not refused.
Yes, my lord, kindly
Page
comes
323.
page 324, my lord.
No, page 323.
Kindly come.
Yes.
Now, my lord, kindly sees subject mitigation of dispute as per so and so. Now, my lord, they are referring with my disputes in detail. My lord, starting from 320.
What is 324?
But this is the reply of my letter dated 1st of December 2023 at page 319. They are dealing with my disputes in detail, my. And my lord, if your lordship kindly comes 332. They have given detailed report dispute wise. Or kindly says detailed item wise remarks as under. First, my lord, delay due to changes in drawings post award of contract and further delays in issue of approval drawings. Then, my lord, B at page 333 chronology of guide bearing. Then, my 2 delay in completion of substructure by agency. So they have dealt with my disputes in detail by this letter, my lord. Now, what else, my lord, the petitioner will do? If that needs to be looked into, that can only be taken care by the learned arbitrator, my lord. Now, my lord, again they are asking for detail.
This appears to be you've dealt it in details.
This
But this letter is an internal communication, it is not addressed to.
it was addressed to the petitioner. Page by way of 323 later, page 323. It was annexed. So they have dealt with my disputes, my lord, and they have refused to address. That is why, my lord, I have invoked that arbitration clause, my lord.
Yes, Mr.
My lord, in that case, my lord, that liberty may be given, my lord, that the claim, whether it is an accepted matters or not, my lord,
Raise whatever you say.
before the arbitrator.
Yes, my lord. That liberty is always there and subject to correction.
Heard by the counsel for the parties, this application on the 11/6 is filed by the petitioner upon the failure of the respondent to appoint an arbitrator. Where is your notice
Well, that is at, my lord, page 355. Dated 15th of February 2024.
Failure to respond to the notice under section 21 of the Arbitration and Conciliation Act, ID, notice dated 15/2/2024. Stop. The petitioner was awarded a contract by the NF Railways in respect of
Construction of 14 bridges.
Where does
Construction
one-
of 14 bridges.
where does one find it?
My lord, kindly comes para 4 and 5 of my application.
Page 27. The reference is that
Yes.
for supply fabrication assembly.
Yes, my lord.
Page 27, reference 1.5. For supply fabrication assembly erection of composite girders for so and so number of bridges and so and so so and so. You are the company who built a bridge which collapsed. Yes, in Siren.
I am not.
Anyway, that is for railways to decide.
Yes.
The contract was completed or terminated?
No. Completed. They have issued completion certificate as well.
Where is that?
My lord, completion certificate is at, my lord.
The railways constructed, the company constructed the executed, duly
Case
executed the
361, my lord. Case 361.
361.
Yes, my lord. Annexure 8.
The works were completed and duly completed, and completion certificate dated 10/4/2024 was issued within bracket annexure 8 in respect of the works. Stop. However, because of the works being completed beyond the time allotted, liquidated damages were sought to be imposed by the railways.
They have already levied. They have adjusted that from my bank grant.
They have been imposed and adjusted from the final bills released to the petition.
But not, that is also my claim. Final bill has not been issued.
Okay. Adjusted against the claims, total claims made by the contractor petitioner, and also that the final bills have not yet been released by the railway stock. Such circumstances, the application under 11.6 has been filed. So, there are the railways have objected to the claims made by filing their necessary objections, on the ground that the procedure prescribed under the GCC of the appended to the contract which is executed by and between the parties was not followed by the petitioners. Was not adhered to by the petitioners. Therefore, the prayer made by the petitioner as ought not to be granted. Well, the The counsel for the parties have been heard. The pleadings available on record have been carefully perused. The relevant clauses. Page number 323. What is that clause? 63, 64?
Yes,
121.
121. The
Clauses 63 and 64 define, prescribe the manner in which the disputes between the contractor and the respondents are to be resolved. Stop under clause 63.1. Matters should be referred by the contractor to the general manager, and the general manager within 120 days should make and notify the decisions on all the matters. And stop according to the railways. The matters which are covered under the clauses specified under 63.1 would be deemed to be accepted matters, i.e. matters not arbitrable. And therefore the decisions on the railway authority would be final and binding. Where does one find these clauses? Page 121.
That will be.
Specific clauses is mentioned in between the paragraphs. My lord.
I know, but where do you find the clauses?
In the
What does it?
GCC, then
Why don't you produce a copy? You produce that copy. Show us that these are accepted matters, arbitrable, not arbitrable. What are these?
may I pray for one submission, my lord?
Hmm.
Even if, my lord, I am taking that these clauses says that there are certain accepted matters which are not arbitrable in nature. My lord, what is my application before your lord? That the arbitrator may be appointed.
See, the court, we accept the decisions of the apex court and several other courts that the referral court, so we only need to see
Existence of the arbitration.
but that doesn't make the High Court a post office, does it?
No, no, certainly not. Certainly.
Then you show us the
Madam,
clauses
may I
these are the
delay-
clauses.
May I delay only one judgment?
You show us the clauses first. Why have you not brought these clauses on record? If it is your case that these are not accepted matters, or even if they're accepted matters, they are deemed to be arbitrable.
That was my case. That even if these clauses are not accepted matters,
Without looking into the clauses to define now.
and so
what
far
are
this,
accepted
man,
clauses.
so far this subject to man, with all the best respect, man, so far this application
You
is
produce it. You'll have to deal with this in the order. Without looking into the clauses, how do we deal with it?
man, kindly keeps it any day, my lord, I will by way of supplementary, my lord.
Keep it for later. Now you write that during the course of the hearing, clause 63.1 upon perusal reflects that refers to certain accepted matters which are matters arising out of some of the clauses of the GCC which are specifically mentioned, clause 63.1. So the council for the parties submit that the entire GCC, or more particularly the GCC containing these clauses, are not on record. So counsel for the petitioner is permitted to bring it on record by filing an appropriate affidavit.
I can file it today because, my lord, I'm carrying the soft copy.
Well, tell us when you want it.
Any day, my lord, subject to your convenience.
Can have it on Friday. Is it good for you, Mr. Gupta? Let this matter therefore be listed on Friday.
Friday, may I appear virtually if you're looking for that?
Can appear. right? Or if you want a later date, we can give you a later date. 28th, it will be 28th. List accordingly. Needless to say, counsel or the parties are permitted to appear through virtual mode, subject to such permission being sought for from the court master in advance. Yes.
May I take your leave?
Yes.
Eight reason.
Yes.
I'm aggrieved by the order dated notification dated 28/11/2024, where my certificate to practice as a notary was not renewed. Your lordship may kindly page 30. May I read it?
Hmm.
In exercise of the powers conferred under Section 3 and Section 10 of the Notaries Act 1950, the Governor of Assam is pleased to reject the renewal of practice of notary certificate.
Page number?
Page number 30.
Please.
30. In exercise of the powers conferred under Section 3 and Section 10 of the Notaries Act 1952, the Governor of Assam is pleased to reject the renewal of practice of notary certificate of Sri Sanjeev Plumber, Notary Public of Tinsukia District, Assam, bearing recent number TSK 05, Tinsukia District, and file number ZBJ 188 006 323, issued on 5/1/2025, tendered by letter number NIL, dated 19/11/2003. Lordship, may I take a lordship to the Notaries Act for a moment?
Notaries Act.
Notaries Act, your lordship. Section 3, if your lordship may kindly peruse for a moment.
Yes.
This is the power to appoint notaries. The central government for the whole or any part of India and any state government for the whole or any part of the state may appoint as notaries any legal practitioners or other persons who possess such qualification as may be prescribed. Then your lordship, Section 4 registers. The central government and every state government shall maintain in such form as may be prescribed a register of the notaries appointed.
Yes.
The central government and the state government shall maintain in such form as may prescribe a register of notaries appointed by the government and entitled to practice as such under this act. Every such register shall include the following particulars about a notary whose name is entered therein, namely his full name, date of birth, residential and professional address, the date on which his name is entered in the register, his qualification, and any other qualification which will be prescribed. Now, your lordship may kindly peruse the Section 5, entry and names of the register and issue of renewal certificates of practice. Every notary who intends to practice as such may, on payment to the government appointing him on the prescribed fee, if any, be entitled to have his name entered in the register maintained by the government under Section 4, and to a certificate authorizing him to practice for a period of 5 years from the date of which the certificate is issued to him. The government appointing the notary may, on receipt of any application and the prescribed fee, renew the certificate of practice of any notary for a period of 5 years at a time. Now, your lordship, Section 9, power to practice without certificate.
Yes.
Subject to the provisions of this section, no person shall practice as a notary or do any notarial act under the official seal of a notary unless he holds a certificate of practice in force issued to him under Section 5. Provided that nothing in the section, so that is, I'm not reading that, your lordship. Then your lordship may kindly prove Section 10.
removal of names from registers. You are not maintaining the register.
Oh, your lordship, that allegation is there, but that particular party, may I reply, your lordship? I had maintained the register, your lordship. No date, this particular allegation, your lordship, if your lordship may kindly find my reply, your lordship, at running page 40, your lordship. 39. Very good. 39, the LCN report especially states in submit no such inspection report from district and central since it exists or has been received by the respondent authority, nor was any such finding ever recorded against the answering respondent. The notary register is duly maintained by the
39 or
39 of my
edition
edition
reply.
of the affidavit reply. Clause 4.2. The answering deponent respectfully states that submitted no such inspection report from the district administration, thus Tinsukia exists or has been received by the respondent authority, nor was any such finding ever recorded against the answering deponent. The notarial register is duly maintained by the answering deponent in strict compliance with Rule 11 of the Notary Act 1956, and all relevant entries are up to date and available to inspection. The respondent authority has failed to produce any cogent evidence, copy of the LS report, or any communication to the district and system, thus Tinsukia in support of his ball. Unsubstantiated allegations and the respondents request to there.
So is there any report or no report?
There is
Document is, fortunately, it was not annexed. Document kindly see the next page. It's specifically mentioned.
So what is the effect of not maintaining it?
Effect is, my lord, there is a SOP, yes, SOP with the petitioner is annexed. So you will find at page 26, it starts. Standard operating procedure on renewal of certificate of practice. It says that,
Where is that page?
page 26. Unless there is satisfactory performance report, they are not bound to renew it. There are 9 what you can see. For consideration of renewal applied for, the department shall consider the following.
Yes.
Says, satisfactory report. And in the rules, it is specifically provided.
So is there any financial involvement in the sense that some amounts are required to be deposited in the treasury? No.
No.
Or the number of.
For renewal, a specific amount is to be paid. There is no dispute about that.
Right.
It is only about his conduct, my lord. The rule 11.5 says every notary shall permit the district judge or such officer as the appropriate government from time to time appoint in this behalf to inspect his register at such times, not often than twice a year, as the district judge or officer may fix. District judge or officer appointed by the appropriate government will have power to lodge a report to the appropriate government for taking action against a notary.
There is no report. There is no report to suggest that any action is to be taken in this report of the district judge.
That is why it was not renewed.
So report of the district judge mentions that this part was not filled up.
Yes.
but overall performance is found to be satisfactory. So there is no recommendation that his notary license should be cancelled or not renewed.
It is, but the order may speak like that, but it's not a cancellation. The word may is there.
Not renewed.
May renew. It's not, they are not bound to renew it. Lordship, kindly have a look at the provision.
No, they are not bound to. But
Yes.
once you have renewed it, unless you want to say that it's caused, these actions or inactions have brought,
I don't know this.
uh,
If the notary doesn't maintain a register, when difficulties with Lordship is aware, nowadays they have to be controlled, because if some gap is there somewhere, after 10 years they will show an execution of a document in that gap. That is the purpose of regulating their conduct and compelling them to maintain a register. And maintenance of register is another act itself. They have to maintain a register. And now it says that he has not maintained the register. And this SOP says, for consideration of renewal applied for, department shall consider the following: satisfactory performance report and satisfactory report on maintenance of notary registers for the concerned district judge as visualized under 11.5 of the notary rules.
why have you not maintained the register?
My instructions are very clear, Your Lordship. I have been maintaining the registers, Your Lordship. And Your Lordship may kindly peruse section 10 for a moment again.
There is a report of the district judge saying that it is not there, not mentioned. He is mentioned that the columns meant and serial number of receipt book are kept blank. Maintenance means it must be filled up in all the columns.
Yes, Your Lordship, but I'm told, ma'am. But Your Lordship, may kindly see D, Your Lordship, section 10D. There has to be an inquiry, Your Lordship, and there has to be a misconduct. Now, whether not maintaining that particular or not filling up that particular part will be a misconduct, Your Lordship. And 10D, Your Lordship, has been married, Your Lordship.
Yes.
A removal of the names from register. The government appointing any notary may by order remove from the register maintained by it under section 4 the name of the notary if he has been found upon inquiry in the prescribed manner to be guilty of such professional or other misconduct as in the opinion of the government renders him unfit to practice as a notary.
This is removal.
Removal. So there has to be inquiry. Now the certificate of practice is not renewed, Your Lordship. Your Lordship may kindly peruse page rule 8B.
8B.
8B. The
Rule 8.
8B. The notary's rule. 8B.
Yes.
The certificate of practice issued under sub-rule 4 of 8 may be renewed for a further period of 5 years on payment of prescribed fee. An application for renewal of certificate of practice shall be submitted online form to the appropriate government before 6 months from the date of expiry of its period of validity. Provided that the appropriate government may, after considering the reasons stated in the application, release the condition of submissions or application for renewal of certificate of practice before a said period of 6 months. Now, in my case, Your Lordship, I have done everything. Yes,
Who is to renew it? Who will renew it?
done by the LR and secretary to the government of Assam.
Let the LR cause an inquiry and file a report and thereafter pass appropriate orders. Heard Mr. T. Devi, the counsel for the Indian Council, additional AD, assisted by MSM Bhattacharya, appearing in the state. Petitioner before this court is the petitioner is a practicing advocate.
Yes, Your Lordship. But not
You still have a license to practice, I suppose.
yes, Your Lordship.
The practicing is enrolled as an advocate on 24/12. 1999 under the Bar Council of Assam, Nagaland, Mizoram, Arunachal Pradesh, and Sikkim. Stop. The petitioner practiced before courts of district and session judge Tinsukia, as well as the courts of Chief Judicial Magistrate Tinsukia. So, it is submitted that the petitioner is a person with locomotor disability. So, in response to the advertisement issued, calling upon the arrested parties to submit their applications for appointment of notary. The district of Tinsukia, the petitioner applied for the same, duly appeared in the interview and was granted, what do you call it, a license? License to act as a notary.
Certificate of.
Where is that?
It's under, my lord, Rule 8(4).
No, the certificate is at page 24.
Yes.
Is that the certificate?
Yes, your lord.
It was issued a certificate of practice.
23 to 24.
And was appointed as a notary. With effect from January 22nd, January.
Yes.
22nd January.
5/1/2015. First.
22nd January 2015. Stop. This license was initially, the certificate of practice was granted for a period of 5 years. Stop.
This is in terms of section 5(1)(b). It has to be 5 years.
This certificate was issued in terms of section 5(1) capital B of the
Small b.
Notaries, small b of the Notaries Act 1952. Subsequent thereto, the petitioner's license was again renewed on 20th of December 2019. So, after expiry, that the renewal was also granted for 5 years.
Yes.
The renewal was granted for 5 years. Thereafter, the petitioner sought for further renewal, which, however, came to be rejected by the impugned order dated 20th of November 2024. Stop. This rejection purportedly was issued on the basis of the report of the district and session judge Tinsukia, on the ground that the appropriate registers required to be maintained are not maintained. The learned counsel for the petition and therefore submits that ordinarily the scheme of the Act, read with the rules, empower the appropriate authority for issuance of certificate of practice and extension thereof. Stop. The rule, the section 10 of the Act provides for removal of the names from the register, and
Not correctly mentioned again. Renewal is under 5(1)(c). Under 5(1)(c), section 5(1)(c).
5(1)(c).
Read with 8(b), capital B.
Are you referring to section 5(1)?
5(1)(c).
There is no C in the book. in our book,
I'm sorry, it's 51B.
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 Right.
This is for entry of names and issue or renewal of certificate.
And 8B, your lordship, of the rules also speaks about the renewal of certificate of practice.
The council therefore submits that the act contemplates removal of the names of the notaries from the register maintained on the grounds mentioned in section 10.
I'm sorry, I'm interrupting your lordship.
Yes.
Section 5, subsection 2 speaks about renewal. Government appointing notary may, on receipt of an application and prescribed fee, renew the certificate of practice. And Rule 8B. 5.2, Section 5.2 and Rule 8.
He therefore submits that there is no inquiry or allegation made against the writ petitioner that he is found deficient in respect of any of the clauses mentioned under section 10, and therefore his name is required to be removed from the registered stock.
The renewal issue is not there. He's saying that it should be renewed.
No, we are recording his submissions.
But here the name has not been removed. Removal is in between. Supposing he has got the certificate.
Removal from the register.
Yes, that is register. Once certificate of practice is issued, his name will be simultaneously registered.
Correct. But if it is not renewed,
then it can go.
The go means it has to be removed.
No matter. First, if the renewal is not granted, it's one thing. If removal during the pendency of his validity of this certificate is slightly different.
Submission is that ultimately it leads to removal from the register because of non-extension.
Pursuant to non.
That is what
non-renewal. Yes.
That is what is submission. Learned counsel for the petition submits that as per to the best of his knowledge and instructions received, all the registers are maintained as per the requirement, and there is no allegation that of failure to pay any prescribed fee or there was any misconduct, professional or otherwise, leveled against the petition. So it's further submitted that the report of the inquiry conducted by the district judge Tinsukia was also not furnished to him. So, case of the petitioner is contested by the respondent by filing their affidavits. Referring to the said affidavit, the affidavit, the learned petitioner submits that there is an SOP dated 1st of June 2023 issued by the Government of Assam Judicial Department for renewal of licenses or renewal of the certificate of practice of notary public, and at clause 9B, there has to be a satisfactory report on the maintenance of the notarial registers from the concerned district judge as envisaged under section 11(5) of the notaries. So the learned additional AG therefore submits that since there is a report from the district and session judge Tinsukia that the registers are not properly maintained, the authorities, the appropriate department decided declined to issue the renewal certificate as it violated clause 9B. The learned counsel, appearing the learned additional AG, further disputes the submissions of the learned counsel to the petitioner that the petitioner was removed under section 10. Stop. He submits that section 10 pertains to provides for removal of the registers on the grounds mentioned on the various clauses mentioned under section 10. Stop. He, however, submits that the renewal of the notary's certificate of practice is prescribed under section 5(2), read with 11(5). 8B. 8B of the rules. Stop. He therefore submits that where the SOP has been violated and there is a report of the district judge, support thereof, the license of the certificate of practice was not renewed. Stop. It is submitted that the notaries have an onerous duty to properly maintain the records in respect of the documents notarized, as it may have serious legal or judicial ramifications if the particulars are not properly maintained. So, under such circumstances, the authorities considered it fit not to renew the certificate. So, for the parties have been heard. The things available on record have been carefully produced. Clause 5 of the Notaries Act, more particularly 5(2) reads as under straightforward. So, it is also necessary to refer to clause section 10, clause 5 of section 5. Also necessary to refer to section 10, which reads as under extract. Under Rule 8 capital B, the certificate of practice issued under sub-rule 4 of Rule 8 may be renewed for a further period of 5 years on payment of the prescribed fee. The provisions of the Act, read with the rules, do not contemplate the refusal of the competent department, do not contemplate non-extension of the certificate of practice. Stop. What the Act prescribes under section 10 is for removal of the name from the register on the grounds which are mentioned therein. Stop. There is no quarrel, there is no dispute that there was no inquiry in any prescribed manner conducted in respect of the petitioner and the deficiencies in his performance were found. Stop. On the contrary, the report of the district judge, Tinsukia, which is not a part of the pleadings, but was placed before the court by the learned additional AG, reflects that the report reflects that the registers from 1/1/23 to 30/06/24 were examined. Registers maintained from so and so by the petitioner were examined by the district and session judge Tinsukia. Stop. However, the columns meant for serial numbers of the receipt book were kept blank in all the registers, and only in a few registers the prescribed fee and the fee charged have been noted. Stop. However, the overall performance of the petitioner as a notary public is found to be satisfactory. Stop. Better. Considering the rival contentions and the issues raised before the court, it appears that the non-extension of the certificate of practice will ultimately entail removal of the name of the writ petitioner on the register as contemplated under section 10. Stop. The removal of the names of register from the register, removal of names of the notary public from the register can be done by the government on the grounds which are specified under section 10. So, this is not to say or suggest that the respondent authorities are duty bound to issue extension of certificate on such applications being filed for renewal of the certificate of practice. Stop. Section 5(2) clearly mandates that the government appointing the notary may, on the receipt of the application and prescribed fee, renew the certificate of practice of notary for a period of 5 years at a time. Stop. The SOP, which is issued by the Department of Law, Judicial Department, also clearly prescribes a satisfactory report on maintenance of notarial registers from the concerned district judge as visualized under Rule 11(5) of the Notary Rules. Stop. The notary rules as described, the in terms of Rule 11(5), the district judge Tinsukia, district and session judge Tinsukia, undertook the examination of the registers and had given a report which is discussed above. So, although the report reflects that certain columns in the registers for that period mentioned are not filled up, the overall performance of the petitioner was found to be satisfactory. Under such circumstances, it cannot be said that the district and session judge had recommended to the appropriate government to proceed for undertaking any inquiry or action against the petitioner for removal of his name from the register and of the goal for non-extension non-renewal of the certificate of practice. So but the fact remains that in terms of the SOP, the petitioner was required to maintain the notarial registers and which have found to be not been properly maintained in terms of the report of the district judge, district and session judge dated 2/8/2024. So this court is of the considered view that a detailed inquiry be undertaken by the LR and the Secretary of the Government of Assam Judicial Department with respect of the application filed by the petitioner for renewal of the certificate of practice. So if it is found that there is no loss caused to the government or to any of the parties, or if there are no further allegations against the petitioner in respect of deficiency in service, the LR will pass appropriate orders giving extension to the certificate of practice as permissible under the Act regulatory rules. This order is passed by the court, keeping in view that there is no fixed salary or remuneration issued by the government to the notaries who are appointed by the government, and their source of earning is to the revenue which is generated by the certificates and the attachments which are made by the revenue, by the notarial practitioners, by the notary public. So let this exercise be completed within a period of 30 days from the date of receipt of a certified copy of this order. Needless to say that the Secretary, LR and the Secretary Judicial Department will call for all relevant documents and reports if required, and pass a speaking order, and copies thereof should be furnished to the writ petitioner. With the above observations, directions, the writ petition stands disposed of, closed.
I'm very grateful, Your Lordship.
Interim orders, if any, stand merged. No order is to post.
I'm very grateful.
Yes.
Lordship, this is a matter, is a pension matter. In the meantime, respondent number 4, who is a dual search secretary, joint secretary, and director, has filed affidavit.
As
Now-
filed affidavit.
They have filed it. Now, Lordship, we have to file counter affidavit. So
Rejoinder. You want to file a reply?
1 week, 2 weeks then.
You want to file a reply affidavit?
Yes, Lordship.
Counsel for the petitioner prays for and is granted 2 weeks time to file rejoinder.
2 weeks time, Lordship, kindly fix it there also.
You want 2 weeks?
2 weeks time.
2 weeks time to file rejoinder, list this matter again on 19th June.
Lordship, otherwise.
Yes.
Lordship, this writ petition is regarding an arbitrary, discriminatory, and malicious transfer order, which is in violation of the respondent company's own transfer guidelines. Along with this, two IAs are there. The first IA is to direct the respondents. What we have prayed for is not to hide material facts. They have misled the court and bring on record material facts. I'll amplify that. The second IA is to restrain the respondents from taking any punitive action against the petitioner, including attempts to manipulate my annual confidential on account of approaching this honorable court for justice. Lordship, besides numerous things, three aspects are striking in this case. The first is most of the facts.
So before you proceed, we'll have to deal with the IAs.
Yes, Lordship, I'm coming to that. I'm coming to the IA. Lordship, firstly, most of the facts have not been denied by the respondents. Instead, the primary plea which the respondents have taken is based that the transfer is based due to exigencies of service and retiring of employees. There has been no reply whatsoever to any both the IAs. Secondly, there has been a series of malicious actions, and since I brought this matter to the notice of the court, there has been a vindictive attempt to spoil my performance management report, basically the annual confidential report, just because I have approached this court. And the company itself, I would like to bring out that out of 13 executives in the last 4 years, 8 have already left. There are only 5 balance, and I am the only girl still left working in the company and that too from the Northwest. And the third aspect is hiding of material facts. I'll come to that, and the brazenness with which they are doing it, despite a court case being pending. They are creating exigencies where none exist. Now let me come to the IAs. I'll take up the first IA 1330 of 2026. Lordship, I'll draw your attention to Annexure 1 at page 11 of IA number 1330/2026.
Yes.
Lordship, the question here is, in the last hearing, the Learned Senior Counsel, when asked about the circular of the respondent company, whereby the period of service had been extended from 4 to 5 years, that is till April 2027. And hence, the exigency which they have been talking about, that people are retiring in April 2026, no longer exists. Had just said that I do not deny the existence of this circular. I would say that the basic foundation of exigency of service quoted by the respondents is that 2 employees are retiring in April 2026, which does not exist now because by their own circular, they are saying that it has been extended by 5 years. So 2022, 5 years, it is expiring in April 27. And why I'm saying it is, I draw your attention, Lordship, to
where is that circular? 10.3?
Yes, Lordship.
10.3, Annexure 1.
Yes.
You bring it by way of an additional affidavit. Why are you filing an IA?
No, sir, Lordship, I'll come to that. Why I'm saying it is that in para 11 of page 81.
So see, either we take up the IA or we take up the main writ petition. If we have to...
We'll take up the IA. We'll take up
So the IA, I'm at page 8 of your prayers.
Lordship.
Your prayer number...
Come to page 11.
Prayer number B to take judicial notice, you can bring it always, you can bring it by way of additional affidavit.
Lordship, why we have given it is, I'll tell you, Lordship, is because I would draw, because they have said two contradictory things. In one affidavit, they are saying,
We are asking you, what is your prayer in the IA?
Lordship, my prayer in the IA is,
Why have you filed this IA?
Lordship, is that they are not bringing out the truth. They are misleading because they have said two different things in their affidavit.
So is this relevant?
Yes, it is relevant.
One is relevant.
It is
So why
relevant.
don't you bring it by way of an additional affidavit instead of filing an IA,
Lordship,
asking us to take judicial notice?
Lordship, because they are giving contradictory things
You
in
don't
their
see-
own dissent.
You're not understanding. You see, we are not ignoring this document. We are only asking you, bring it on record by an additional affidavit. Where was the need to file an IA, asking us to take judicial notice?
It was because there is still 1 year left, and there is still 1 year left, and they have, in spite of 1 year, they are insisting that no, it is.
All right, we are dismissing your IA. Heard Mr. D.S.
Lordship,
Bhattacharya,
there is
learned
one more
counsel
IA.
for the petitioner. His IA has been filed, IA number so and so is filed with the following prayers. The writ petition is pending and the petitioner is permitted to file, to bring on record any documents that they feel would be necessary, subject to permission being granted by court by filing the appropriate pleadings. Under such circumstances, this court does not find it necessary to entertain this IA. Accordingly, is dismissed.
Lordship, I may be permitted to file an application.
We have already said that.
Lordship, I'll come to the
Subject
second.
The permission being granted. You'll have to satisfy the court that
Lordship,
the additional affidavit is necessary. Yes, number two, yes, what is this IA for?
Lordship, since I have approached this honorable court, there has been a series of retaliatory and vindictive approach action against me, including attempts to manipulate my annual performance. And just for one reason that I have approached, I'll draw your attention to IA 1621
Yes.
of 2026.
Yes.
Lordship. Lordship, there are 4 questions which arise in this. The reporting period, the PMR, Performance Management Report, is for the annual, is from 1st of April 2025.
That is not the issue in the writ petition.
Lordship,
The issue in the writ petition is a challenge, plain and simple,
Yes.
to your transfer order.
It's related because
You are entitled to raise these issues. These are all different causes of action.
No, Lordship, it is related. Why? Because I am being put under the same person.
Whatever it may be,
Under
you are
the same
entitled
person
to.
against
You are
whom?
entitled to raise this by way of separate pleadings and proceedings if you
Lordship,
choose
but
to.
this is- Lordship, but this is-
What has this got to do with the transfer order?
Sir, Lordship, because this is a serious, I have raised questions
Other
about.
day already your
Lordship,
lordship
please.
indicated him that if you,
It is, you are giving next time. I'll also.
please, whatever you want to say, you just share.
I'm saying.
You are
I'm
not
talking-
a regular practicing lawyer. That's the problem.
Lordship,
No,
I contest this.
Yes, I am saying it and I'll say once
Lordship,
again.
I contest it.
Well, what
We
he is
should
doing,
not
my lord,
come to
on
personal.
the last
this thing.
occasion your lordship indicated him. It's a different cause of action. You can come up with
He
a,
could not come to
but
personal.
in this
this
case,
thing.
why you are want to stall in this proceeding?
There is no question
come
of
up to
stalling.
the main-
I have a point.
Main issue.
I have a point. I am approaching the court. That doesn't mean that he approaches this thing. He gives personal.
He has a right. He has a right. You can't deny
Lordship,
that.
that should not
He has a
come
right
to
to reply if he finds that this
personal this thing. We are talking about the case.
No, I didn't hear anything
Yes,
personal.
Lordship, he
No?
mentioned that.
I don't know it's personal.
What personal
Lordship.
matters was brought up?
Lordship,
We are only saying that if you're alleging that the person who's in charge of giving you the, what is that, PMR?
PMR, Lordship.
If you are aggrieved, you have different cause of action.
No.
How is this connected?
Because
It may be connected is a different issue. But if you want orders, then you have to put it to specific challenge,
Lordship, that is.
and not by way of an IA.
Lordship, the IA is because it is related to this.
So it may be related, but then that will be expanding the scope of the writ petition. Why should we?
Lordship, the point is, just because I have approached this court, I am being, all these punitive actions is being taken just because I have approached the court. Because, Lordship, the whole period is over. I have served under someone else.
No, we have brought it to your notice that if you want, you can file separate. These are separate causes of action.
Lordship,
there are procedures for doing it. Even if you say that this is connected to the writ petition, but the writ petition essentially is challenged to a transfer order.
Lordship, I may be permitted to file an addition.
File it.
Lordship.
Additional or otherwise, we don't know. If you want to do it, you do it.
Lordship, I may.
Then you are withdrawing this I?
With the Lordship, with the permission that I may be permitted.
The petitioner submits that the does not wish to press this IA any further. However, he seeks liberty of the court to file appropriate pleadings or proceedings. If so advised in the meantime, prayer made is not objected to by the learned senior counsel appearing for the respondents. Accordingly, IA so and so stands dismissed as not pressed. With liberty.
With liberty, I may be granted 2 weeks time.
But there is an interim order you are enjoying.
Yes, Lordship. But the whole basis, the whole fact, if I may come just, Lordship, the whole is they have given 2 different.
See the parameters of interference in a writ court for transfer is extremely limited.
Lordship, but there is malice involved.
So malice
is it? That is one of the ground. There is malafide intent. There is present.
Malice.
Malice is what we are insisting.
Is it personal malice? Malice in
malice in law.
Malice in law.
That is what we are. The whole thing is coming out from malice in law.
Yes.
So, Lordship, I may be permitted 4 weeks to file it.
You file it, that's a different issue. But what do we do with this writ petition today? It's a question of transfer.
Lordship.
Malice, if you are challenging it, then you bring it or you have to place it before the court.
Will Lordship will.
How is malice?
It is violating the company's own guidelines.
No, guidelines don't give you an accrued right unless you want to urge before the court that there is an aspect which may be examined to say that it does give you some rights.
Yes, Lordship, there is in fact, because there is ill will, there is spite, there is revenge, and
all ill will and spite is not going to rise to malice in law.
That will come under malice in fact.
So if it is malice in fact, then you have to make allegation.
And also malice in law, this thing, it is an intentional wrongdoing without any lawful excuse. My period of service was till 31st of March 2026. 4 weeks after that, I am being told that you have to show you are being put under someone. You are being put under someone under whom I have not served for even a single day. And the fact remains is that this similar person is the person who has been persecuting.
Have you made any complaints against this person?
Yes, Lordship. It is there both in on paper and verbally and on paper.
Where are these complaints made?
Lordship, I'll be Lordship before this thing. I'll put it up.
They bring it up on by Monday. No further time.
Lordship, week's time maybe.
No. You're enjoying a stay order.
Lordship, but the whole thing is that it has.
What is the benefit of enjoying a stay order? If you are confident that we can, you have a
Lordship, I have to get the
make the
documents.
stay order absolute.
I have to get the documents. Lordship, whatever you.
Monday, whatever you want to say it before us, Mr. Lotto.
Yes,
Some allegations of malice.
let him show. He could have shown. But
ought
on
to
the
have-
contrary, Melody, if I take your lawsuits to the writ petition, para 20, his stand is very clear. Para 20 are just read out. The petitioner is seeking only 1 year deferment and not seeking cancellation of the transfer. She is willing to accept the transfer proceedings after 1 year. Now, the ground was that her mother is not keeping well. So by this time, 5 months is gone. So this is the only ground. And now he's saying that malice.
No,
in fact,
Lordship, this
malice
is
in
not the
law.
only ground.
Is there any pleading? There is nothing. Because malice in law and malice in pleading something you have to state, some other statement in pleading some, those people against him you are saying on that.
You see page number 20. I'm sorry, paragraph 20, page number 13.
Lordship.
You are only seeking deferment,
That was one.
not cancellation.
That was only one. That was only one out of the numerous. If I go to Lordship,
No, but if you're alleging malice, then is para 20 statement?
no, that was one of the grounds. That was not all. Lordship, if I may be permitted,
Again, at 23, you are saying requesting for 1 year deferment.
because that was at that point of time mother's treatment. Lordship, and that order was given when I was on leave, despite knowing that I was on leave.
You bring materials
give
by
them.
Monday to say that you are being subjected to harassment.
Lordship,
Otherwise, we are dismissing your petition.
Lordship,
Because now you're giving a different, attempting to expand your case, which was originally projected before the court.
but this is already existing because we have said two different things. Lordship, if I just take 1 minute and bring your attention to para 11 of page 81, or we can do it for
11
Monday.
11 of?
Page 81. And I'll draw specifically to page 122.
Para 11, yes.
Yes, page 81. Where they have repeatedly, para 11 of page 81,
Yes.
para 13 of page 11 of page 81, last line. Last line. They have talked about 4 years that it's expiring in April 26. Now, para 13 of page 82, fifth line.
Yes.
Again, the same contention. Para 31C at page 98 on the sixth line.
Yes.
Again, the same contention. Then para 6 at page 126. That is in the additional affidavit given by the respondents. Again, they have talked about April 2026. That is the whole thing on which they are basing. Now I'll draw your attention to page 122. Page 122 of the additional affidavit submitted by the respondents. I'll draw your attention to serial 3. Lordship, Mansi Agnew, Lordship. Now, date of joining 22/04/2022. Joined at a corporate and still working, and contract is set to expire in April 2026. 2022-26. I will relate this to annexure of the respondents, annexure 8, annexure 8 at page 145. Second paragraph. Ms. Mansi Agnihotri is appointed for 1 year, which may be extended annually based on work performance. However, contract shall not exceed 5 years. Lordship, no amount of mathematics will prove that 2022 plus 5 is 2027 and not 2026, which they have said on the affidavit. Okay. So the whole fact that exceedances of service April 26 is what they have been repeatedly saying, the whole thing collapses. And this, despite my mother being so ill, and I was on leave, they knowing that I have come for my mother's treatment. During the pendency of that leave, knowing that they have asked me to join within the leave period. And that too through WhatsApp. If this is the way a company functions, if it is not malice, what?
Where is that WhatsApp message?
Lordship. Lordship, I draw your attention to the annexure 1 at page 26. Sorry.
Picture 1, yes.
Yes, this was sent to me through WhatsApp and officially through WhatsApp, and officially what I was given, Lordship, I will officially I was given of someone else, Lordship, on my decision. And all this took place during the period of my leave when they knew that I have come for just 20 days to look after my mother, when I had to take her out for treatment. And they have given me, Lordship, just 1 week's time during pendency. What was so urgent that...
But subsequently, I think it was extended to 2 months. To 2 months or something like
Lordship, because that was to cover up the fact that they had actually, on my official mail, sent someone else's. They had not sent it to my mail.
Where is that? Extract of the mail?
Lordship, I'll first. And this was done only after we have, Lordship, I'll just. Lordship, Annexure 7 at page 44. Yes, if you come to page 44, 45, 44 is the first page.
So where is the extract of your email that somebody else's order was
Yes,
sent?
page 45.
45.
45.
45 is the office order to one.
Yes, but it is not to me. It is to someone else, Ajay Vashish. And Lordship, if you see the last line, it has been sent to my email. Last line generated from the email ID, my email ID. So it has been sent to me, Lordship. And they expected that this is what has been sent to me.
This could be a technical error or a procedural error, whatever. Errors do happen.
Lordship, after I brought it to their notice, still they did not correct it. Errors are there. If I make an error, I make a this. Lordship, we have pointed out.
We'll come back at 2 p.m.
Lordship. Otherwise, Lordship, Monday will be.
Monday?
Lord, I was thinking that your lordship fixed it, but then he's started arguing. If your lordship finish it today, it's better.
Wants to come up with some other additional material.
Lord, by installment basis, he has done abundant.
That final opportunity will grant it. Matter be listed on Monday, enabling the counsel for the petitioner to file additional pleadings, if so advised. Copies must be served to the respondent counsel by then before the next date. List accordingly on Monday, 25th.
Lord, the matter will be
Much
hard.
Monday.
All right.
Much.
Obliged.
Lordship,
May I take your lordship's link to mention a matter at this hour?
Yes.
The item 22. I'm having some personal inconvenience, Lord. Your lordships will continue sometime.
22.
22. I've taken the consent of my learned friend also.
If otherwise not inconvenient, can it be taken up on 9th?
No. Let it go to July.
Oh, Lordship, there was some urgency.
What urgency? 2017 matter.
Lordship, it was hard once and then Lordship,
The discipline proceeding matter.
this man is suffering from various ailments. Pray that Lordship.
Bank matter.
Yes,
New
Lord.
India Assurance.
Yes.
New India Assurance.
Already ninth. 9th of June. Item 22. The request of Mr. S. Dr. Singh, counsel will be responded. But to be listed on 9th of June.
Obliged.
And P. Sharma for petition. Yes, who's there for the respondents? Finance. Heard counsel for party, the writ petitioner was engaged as a master role worker. The year 1977 is under the Executive Irrigation Department, Mechanical Division, on a procedure. And worked in that capacity till 1998. Thereafter, he was appointed as a helper on officiating basis, stopped according to the petitioner, served for a period of more than 20 years uninterruptedly. However, his services were not taken up for consideration for regularization. He approached the court by filing WPC 4276, where the petition is disposed of by an order dated 13/8/2002. Where is that order? You had filed the earlier writ petition. Where is that order? WPC 4276. Directing the respondents to consider the case of the petitioner for regularization services if service benefits in terms of the relevant circulars. Thereafter, petitioner was claims to have been appointed on a regular vacant post as an office PM. Same establishment by order dated 51 of 2005/6 dated 8/8/2005 by the Executive Division, Mechanical Division, Konakpur, Silchar. Yes.
I apologize for was stuck up in some other court, madam. Here is a case where, my lord, the petitioner has been found to be covered under the OPS scheme. In the meantime, my
Well, the
lord,
matter was settled in a mediation process.
not specifically.
Yes, there is a report.
We have not considered, my lord, as far as finance department is concerned.
Don't know.
Yes.
The report is there.
So we have not considered, my lord.
Go by the report.
Here is a case, my lord, where there is no serious dispute. The only dispute involved here is, my lord, whether the amount contributed by the petitioner when his, my lord, NPS contributions were deducted, his share was deducted and the government had also made contribution. Now, for some time, my lord, the exercise was undertaken in pursuance of, my lord, the new pension scheme. Later on, my lord, he was found to be covered under the OPS. Now, since he is found to be covered under the OPS, definitely he will get the benefits arising out of the, my lord, 1969 pension rules. But the fact remains, my lord, that for that interim period, for which, my lord, contributions were made by the petitioners and parallel contributions were also made by the state government, my lord, that amount, with respect to that amount, my lord, what would be the procedure? In that regard, my lord, the views of the finance department is awaited, my lord, and the finance department is going to issue a notification to cover up this kind of matters, my lord, where some, my lord, contingencies arises, some complications arises. They will fix up a guideline, my lord, to how to deal with this kind of matters, and eventually the contributions made by the petitioner will be deposited in his account, my lord. Because since it was a contribution made under the NPS, and later on he is found to be covered under.
So there is a mediation report here.
But we have not considered with all respect.
We don't know it is there.
Yes.
The matter has been voluntarily agreed to settle disputes.
We have
Executive Engineer Borkola Katigura.
Because I do not represent, my lord, the executive engineer, my lord, the irrigation department. Now, at the end of the day, my lord, it is the finance department who will have to meet up, my lord, the liabilities, my lord. So far as the contribution, adjustment of the contributions made under the NPS scheme is concerned. Only to that extent, my lord, the finance department is going to, my lord, publish a notification prescribing the guidelines, my lord. what
So
will be
you
the-
don't dispute his entitlement.
There is no disputed per se here.
Then only thing is that you have to take out whatever notifications are required. You do it within a time bound manner.
Can also be done, my lord, but if lordship accommodates me for some time, because he is getting, my lord, he is not financially deprived.
We would have had there the mediation order not been there. Mediation is clear that it has been amicably settled. Now, how this mediation continued, you were not there, we don't know.
My lord, that is the difficult thing we had never considered, my lord. In fact,
Mr. Upadhyay was there.
yes, my lord, we have never. We have not considered, my lord.
I do not know.
No, we do not remember, my lord. We have not considered.
May I please, your lordship, there is a letter also now pending with the finance department by contribution, his contribution is as on September is 3,62,000. There is a letter addressed by the treasury officer, new chief judge branch to the this line is pending in this. There is a letter.
Regular vacant post. Office PM, same establishment. By order dated 51 of 2005-6. Dated 1825, issued by the executive engineer, irrigation mechanism, procedure. The stop it was mentioned in the said order that government servants joining service of the state government on or after 1st of February 2005 shall not be governed by the existing Assam Services Pension Bill 1969. Submitted that stopped deducting the GPF contribution from monthly salary of the petition. Stop petitioner submitted representation before chief engineer, apprising the position of his service status and that his service condition and benefits will be covered under the government OM number so and so dated 20th of May 2009 and OM number so and so dated 18/3/2010 to give him all service benefits under the Assam Services Pension Rules 1969. So, since in spite of the representation filed, there was no response from the department, petitioner approached this court by filing WPC 7636 of 2016, which case and which matters to disposed of by order dated 25/4/2017, granting liberty to the petitioner to file fresh representation before the respondent number 1, namely the Commissioner and Secretary, Government of Assam, Irrigation Department, and further direction to the respondent to consider the same on merit and dispose the matter within a period of 6 weeks. Stop in deference to the same direction. The petitioner filed the representation dated 8/8/2017, the respondent number 1, and there was no response. Stop being agreed, the present petition has been filed. Notice in the matter was issued on 30/11/2018. Thereafter, several opportunities were granted to the respondents, but no response was filed by any of the respondents. Stop. The matter stood referred in mediation by order dated 26/8/2025. So thereafter, the matter was referred back to the court. Although, stop. None of the parties perhaps brought to the notice of the court that there was a settlement arrived at in the mediation, as per the mediation report submitted by the Secretary, Gauhati High Court Mediation Center, dated 14/11/25. Stop. By the said mediation report, matter was settled between the parties. The respondents had assured for release of the accumulated NPS pension at the earliest, enabling the petitioner to meet the legitimate financial benefits that he is entitled to. The mediation report on settlement is extracted below. Extract only. In terms of the settlement arrived at, final GPF amount of rupees 33,130 was stated to be payable to the petitioner. The accumulated NPS fund in respect of the petitioner has not been released as a formal proposal from the concerned BDO and Treasury officer. It has not been received. However, urgent steps were required to be taken in respect of the said claim. So, when the matter is called up, Mr. R. Botuzari, Learned Counsel, Standing Counsel Finance, has placed before the court communication from the Treasury Officer signature to the Director.
No, my lord, it has been placed by the petitioner, my lord.
Or is by the petitioner?
Yes, my lord.
Placed before by the court, by the petitioner, that the proposal for drawing up NPS contributional amount from Tier 1 account due to exit from NPS to superannuation in respect of the petitioner has been forwarded. His total value of holdings as on 4th of September 2025 is 8,42,195.30 with total contribution to his account on 4th of September 2025 being rupees 3,62,056 and total gain is 4,80,130. Stop. The Learned Standing Council Finance, Mr. R. Bortugari also submits that in principle there is no dispute that the amount contributed to the petitioner by the petitioner is required to be withdrawn and
No, so for my lord, that whether he would be covered under the OPS because no affidavit has been filed, number one, and there are no materials or record to even remotely suggest, my lord, that he will be covered under OPS. So that aspect of the matter.
this is the letter of the Treasury Officer.
NPS is not at all disputed. So
Oh.
far as OPS is concerned, my lord, that your
What is
lordship-
OTS?
my lord, old pension scheme.
Wow.
Whether he is covered under the 1969 rules, that lordship will be pleased to relegate the petitioners to the authorities. My lord,
That from 2017 or 18 you have not been able to decide. Now if you delegate to the department, you will take another 20 years to decide.
No, my lord, because there is no materials on record. Therefore,
What
my
can be
lord,
done? You have not filed it. What can be done?
No, my lord,
We'll
that-
have to allow the writ petition on the basis of materials available.
Because my lord, in the mediation proceeding also, my lord, the finance has not participated. Lordship will kindly consider my submission. My lord.
No. Even if we don't rely on the mediation, but from 2018, there has to be some explanation that
Yes,
department has taken some steps.
yes.
Like that. Now at this position to remand it back.
Because my lord, admittedly, my lord, the petitioner is covered under the NPS. Now, he has raised the dispute, my lord, that he needs to be covered under the old pension scheme. To that extent, my lord, there is no admission on record. That is my humble submission.
So admission is not there because you've not filed.
My lord, I have not filed, my lord.
You have not filed. Therefore, there is no admission. Therefore, we'll have to decide on the matter on the basis of the materials available.
Because there, if lordship would be pleased to see, my lord, the earlier round of litigation order, my lord, at page 28. There also, my lord, there is no finding of the honorable court, my lord, that the petitioner is, my lord, covered under the 1969 pension rules, my lord. It is only to the extent, my lord, that he will file a fresh representation. For a moment, my lord, page 30, my lord, with all respect, my lord. Page
What order was passed in the earlier representation?
Yes, my lord, that lordship will see at page 30 of the petition, my lord. Page 30. The second paragraph, my lord.
Yes.
Page 30, the second paragraph, my lord. If I may read
No,
it.
no.
my-
What was the finding of the irrigation department
So,
in the
irrigation,
representation?
there is no finding, my lord. Because irrigation is the employer. Finance is not the employer, my lord. So whether he is covered under the OPS or NPS, it is for the employer, my lord, at the first instance, my lord, to take a call, my lord. Then only the proposal will be sent to the finance department, my lord, for regularization, my lord, regularizing, my lord, the account and then, my lord, disbursing the benefits, my lord. Therefore, at page 30, my lord, with all respect, my lord, second paragraph. Having heard the learned counsel for the parties and on perusal of the office memo, this court is of the considered opinion that the grievance expressed by the petitioner deserves proper consideration at the highest level of the department. Such being the position, this writ petition is disposed of by granting liberty to the petitioner to file a fresh representation before the respondent number one, that is the irrigation department, my lord, ventilating his grievances in the matter. If such a representation is filed by the petitioner within 4 weeks from today, the same shall be considered on merit and be disposed of within 6 weeks thereafter by issuing a speaking order. Now that has not culminated, my lord, in issuance of a speaking order, which I do not find, my lord, in the writ petition. Therefore, the authorities haven't taken a call, my lord, the irrigation, the employer, my lord. The employer hasn't taken a call.
Yes. You have agreed to pay him this year.
The in fact, Office of the Accountant General. GPF will be issued.
Huh?
GPF authority also.
GPF. Then
The in fact, he's getting the pension from old pension scheme. No,
you're getting it.
no, he's getting pension. No.
Then only these contribution has to be.
NPS. Under NPS.
Only NPS.
Because my understanding, Lordship, he is converted from NPS to OPS. No.
Mr. R.K. Talukdar, standing counsel, accountant general, has placed before the court a communication issued by the senior account officer to the executive for Gauhati regarding the GPF account relating to the petitioner. So it is further submitted by the standing counsel litigation, and as also the accountant general's office, counsel for the accountant general, the petitioner is receiving his pension, drawing his pension under the old pension scheme. The only grievance before the court is revision of the amount contributed by the petitioner earlier under the NPS. Stop. Having considered the submissions made, this court is of the view that the amount, since the petitioner is stated to be receiving the pension under the old pension scheme.
Yes, but it is this statement.
No, it is the statement of the accountant general.
No, my lord, that Lordship will kindly
own
consider.
statement.
His own statement, Lordship will kindly consider, my lord. There is no material. There is no material on record, my lord.
Of the statement made by the council that is receiving pension under the old pension scheme, although no materials are placed before the court.
My lord.
The respondents chief engineer irrigation will take all steps necessary to refund put up the necessary proposals towards refund of the contribution made by the petitioner under the NPS.
Yes.
Once that the proposal be made within 3 weeks from the date of receipt of a certified copy of this order, and thereupon the finance department and all other finance department will pass necessary orders within 30 days therefrom. State petition disposed in terms of the order.
And so obliged, my lord. Obliged.
Well, yes.
Mr. Tar is still on next Lordship for the same matter.
This is not acceptable. Is he the only public works standing counsel? Good. What is your claim?
Non-payment of family pension.
Why is it not been released?
Because the husband of the petitioner having master of worker and regularized in the year 2005. Prior to that, he died, during the course of service, but
According to you, he was not regularized.
regularized, regularization order, his name is reflected, Page 17, my lord.
No, but we wanted you to apprise the court as to how the executive engineer can pass orders for regularization.
But in pursuance of the government order, my lord.
Which government order?
Well, it is reflected, my lord, in pursuance of
stated my lord, please kindly see page 17, my lord. In pursuance of under secretary to the government of Assam PWD so and so 13/3/2005 following master rule laborers appointed prior to 1/4/93 and still working without any interruption to break in service are hereby regularized as grade 4 post for master rule with effect from 22/7/2005 and allows to draw the time scale of so and so and so and so. And this my lord, serial number 158, my lord. The list my lord can be see page 22, my lord. Then part B, my lord, on bracket, my lord, it is stated, my lord, expired. Join on service, my lord, 1/4/1990. And respondent number 4 filed a affidavit, my lord, respondent civil engineer, my lord. Kindly see paragraph 5.
Yes.
That with regards to
There are orders in this regard.
my lord.
Where are these orders?
My lord, I have submitted, my lord.
Enclosed to the petition.
No, my lord. In the morning, I have submitted, my lord. Government order, my lord. 22nd
No,
August
not government
2005.
order. We wanted there are orders passed by this court.
Coordinate bench passed the similar, passed the order, my lord, on similar line.
Which is the
My lord.
judgment?
Judgment, my lord, WBC number 3781. That case also, my lord, the husband of the petitioner died prior to, my lord, date of regulation.
Paragraph?
Paragraph of, my lord. 8, my lord. First 6. So discuss the
No,
communication.
here is a case in this Renu Hazarika. He died before the cutoff date.
Cut-off, my lord.
But is it similar here?
Similar, my lord. Ruler with effect from 22/7, my lord, 2005.
And he expired on?
Expired. Petitioner, husband of the petitioner died on, my lord,
10/11.
10/11/2004. Cut-off date 22/7/2005.
So what will be the effect of regularizing a dead man?
But in the communication dated 22nd August 2005, my lord, this paragraph number 3. Category stated, my lord. If, my lord, the guide or superintendent a prior to regulation, my lord. Then, my lord, paragraph number 3
Paragraph 3
of the, my lord, communication dated 22nd
page
August.
number?
Page number 3, my lord. My lord.
Page number 3.
Yeah, yeah. In the morning, I have submitted. Yeah, common.
Yes, yes, yes. Page number 3.
Point number 3.
Yes.
For regulation of the 6 numbers of worksite workers and 42 numbers of master road workers in PWD, 1 number of master road workers in the water resource department, and 12 numbers of master road workers in handloom, textile, and sericulture department who have been engaged prior to 1493 and have either attained the age of superannuation or expired after rendering continuous service, the respective administrative department will create a superannuation post in appropriate date in respect of workers and in date 4.
When was the decision taken to include his name?
Well,
Yes, Mr. Goel.
Rahul was appearing, Rahul Dhar was appearing, but one affidavit has been filed by PWD.
You admit that his name was included in the list,
Yes, it has been admitted.
but he died.
Yes. Before regularization, he died.
So there was a decision taken during his lifetime to put his name. So merely because he died, which is again.
Whether a person who is not in service can be.
No, but his name is there. Therefore,
Yes,
on the
name was forwarded during the process. It was
forwarded.
In 2039, 2005, in the list of
How many years has he completed on the date of his death?
12 years, 12 years, 7 months.
And what is the requirement?
Before he died during the course of service, Rule 140, minimum 1 year.
1 year. So if it is to be counted from 22/7/2005, then what will be the number of years?
13 years,
That 1 year will have to be as a regular employee. It cannot be counted, like for pension, it can be counted from the date when you were initially engaged as master worker or casual worker. That cannot be, that cannot be applied, in case of family pension. As a regular employee, after his regularization, he will have to serve for minimum 1 year to have the family pension.
But what is the status of judgment by coordinate bench in similar issues?
In fact, in the regularization order, of 22/8/2005, there was a chart, there were certain conditions that probably in that case I faced some relief was in similar cases.
Where is Mr. Dhor?
There is a lakes in port number 6, some matter is going on since the first half.
We take it up day after tomorrow.
Not
He's surprising. Day after tomorrow. As it is submitted that Mr. R. Dhor, Standing Counsel PWD, is not available. And that he's been entrusted the matter. Such circumstances, release this matter day after. So I get there for counting and we are partnering. So
Yes.
My lord, in this case, my lord, the petitioner was alleged to be, my lord, unauthorizedly absent from, my lord, 14/9/2024, your lordship. And accordingly, your lordship would find, my lord, a so-called notice was issued to the writ petitioner, your lordship would find at page 21 and exact 2, your lord. So, my lord, statement of allegation, page 23, and he submitted, the writ petitioner submitted his reply, your lordship will find it, my lord, page 24, exact 3. Now, second paragraph, my lord, his case is that, my lord, he went to his house to see his mother who was seriously ailing, and there he himself fell seriously ill, your lordship. Suffering from, my lord, malaria, my lord, a life-threatening disease, your lordship will find. Medical certificate was attached. And thereafter he said, my lord, that he recovered from illness and now in a position to join the duty if the authorities may allow him a chance. And that was, my lord, the presentation was 16/4/2025. The authorities, my lord, did not allow him to join, and accordingly matter, my lord, was dragged on, your lord. Now, all these medical certificates, your lordship will find, my lord, at page, my lord, 26, etc., your lord. Now, my lord, under these circumstances, your lordship will find an order was passed, your lordship, at page 43, your lordship. And, my lord, page 44, your lordship will find, last but one line, as such it unauthorized absence from 14/9/2014 to 23/9/2015, total 375 days is treated as leave without pay. So his unauthorized, my lord, period of unauthorized absence was regularized, your lordship will find, by this particular order, your lordship.
Yes.
Now, my lord, your lordship may kindly see, my lord, the impugned order at page 45, your lordship. This order, my lord, court has, my lord, the authority has stated out some other facts, and again, my lord, page 46, third paragraph, your lord. Again, from 14/9/2014, he remained unauthorizedly absent from the battalion headquarters, and several communications were made to him to resume duty and to appear before the inquiry officer for recording his statement in this connection. With the
Where is the inquiry report?
inquiry report, your lordship will find at page 38, your lordship. Now, my lord, alleged period of unauthorized absence, my lord, 14/9/2024 to 23/9/2024, and ultimately, my lord, they have allowed me to resume my duties on 24, my lord, 9/2015. Now, my lord, page 38 is the inquiry report, your lord. Now, in this inquiry report, your lordship will find, my lord, that inquiry officer did not, my lord, stated that my absence from, my lord, duties was, my lord, willful, or it was intentional, your lord. Nobody has, no, my lord, prosecution witnesses, nobody has said, and it was, my lord, page 39, after several correspondence, and so Gautam Vishal resumed his duties, my lord, on 24/9 after unauthorized absence from 375 days. And unauthorized, my lord, absence of duty, it was for 375 days, my lord. Not it is not 5 years as contemplated, my lord, under FR 18. And nowhere, my lord, findings of the inquiry officer, your lordship, that this particular unauthorized absence, my lord, was intentional or willful, your lordship. Now, until otherwise it is willful, my lord, no, my lord, penalty for removal of service can be imposed, my lord. That is the law all through, my lord. And your lordship will find impugned order for the same period. Firstly, it was regularized, my lord, and secondly, for the same period, your lordship, page 46, he is removed from service with immediate effect here. Now, my lord, he filed an appeal, your lordship. Departmental appeal before the authorities. There was some delay, your lordship, due to his illness and all that, my lord. Now, authority, my lord, did not entertain that appeal, your lord. Now, that particular order, your lordship will find at page 54, your lordship. Third paragraph, as per Rule 17, Assam Services Discipline Appeal Rules, he had preferred his appeal within 3 months. He had to prefer his appeal within 3 months from the date of receipt of removal order passed by the disciplinary authority. But the appellant, Gautam বিশ্বাস, has submitted his appeal petition after a long gap of 12 months without indicating suitable reason for this erroneous delay. Hence, the appeal petition could not be considered and it is rejected accordingly, your lord. Now, this Rule 17 itself says, my lord, that even after that period, it would be entertained, my lord, if the authority so pleases, your lord. So, that is the, my lord, sum and substance of this case, your lordship. And, my lord, I take your lordship to, my lord, FR 18 first, your lordship, fundamental rule. Fundamental rule, my lord, 18, it reads like that, my lord, unless the governor is to be or the special circumstances of the case shall otherwise determine after 5 years of continuous absence from duty, elsewhere than 47, whether with or without leave, a government servant shall be removed from service after following procedure laid down in Assam Services.
Is FR 18 referred here?
FR 18, your lordship.
Is it referred by the disciplinary authority?
My lord, they did not refer. They said, my lord, it is the, my lord, admitted position that it is not 5 years, it is only 375 days.
Right.
Some more than 1 year lost. So this is one aspect, my lord. And second aspect, your lordship will find FR 73, last 2 line, my lord. Willful absence, my lord, from duty after expiry of leave may be treated as misbehavior for the purpose of Rule 15. Nobody has stated, my lord. Nobody has stated either by the inquiry officer or the disciplinary authority in the impugned order.
What is willful?
Willful means
where is it defined?
Intentional. Now, in this connection, my lord, I would like to rely on a decision of the apex court, my lord, Krishnakanta Parmar versus Union of India.
That is the case of overstay.
The same thing, my lord. Authorized.
No, how can it be same thing? You are on leave. You did not choose to inform your authorities for 375 days.
No, I informed I wanted to join. They did not allow me to join. That is my reply I have stated, kindly allow me to join. They said no, in this way they drag the material. Now, if your lordship.
You were absent for 506 days.
Here
Part
in
of
this
it was condoned.
my case, they say I was unauthorizedly absent for 375 days. Rule say for unauthorized absence for removal, period required is 5 years. And 73 says therefore that it must be intentional or willful.
There's rules for the respondent.
Now, here in this case, my lord, one decision I like to submit.
Rules for the respondent.
So see, there is a difficulty on part of Mr. Kumar today. He was here, but he left for a medical appointment.
Now,
Where are the records?
The records are with him, Lordship. So he has asked me that if the petition is okay, he must make his submissions. We will make his submissions on Thursday.
As if the court has no other business
Sorry,
to continue hearing or in piecemeal.
now this
I'm
case,
sorry,
Why are you presuming that it will take the whole day to understand the case of the petition?
No, Lordship, the thing is that we had to leave
At
for
least the records could have been handed over.
same stand, my lord, they are still.
We will help ourselves with the records to find out.
And in so many occasions, matter was, my lord, part hard, then ultimately they did not cooperate, my lord, and ultimately it was released. Then again part hard, then released. Again part hard, then released, my.
Which orders?
Well, there are some orders your lordship will find, matter was part hard again also. Not before this honorable court, before some other honorable benches, your lordship. But ultimately, my lord, matter.
No, but how is Parmar applicable here?
My lord.
How is Krishnagant Parmar applicable
Now,
here?
my lord, here in this case, my lord, is Krishnakanta Parmar, your lord. You are the, my lord, employee of the central government, police organization, intelligence bureau, your lord. I will find. And I submit this decision, my lord, before your lordship.
No,
your
before
lordship.
you submit the decision, you must call out the facts to say under what circumstances you were on leave, why
My lord,
you
I
could
have
not
stated
intimate,
my mother was, my lord,
where were your medical documents
my lord,
in
my
support.
lord, this is reply, your lordship. My reply, my lord, your lordship, may kindly see after I have got this proposed notice, my lord. I filed this reply, page 24, my lord.
Yes.
So
Where are
due
the
to
documents?
serious illness of my old and ailing mother, I came home with a view to see her and to arrange medical treatment of my mother. And that I may return to duty, I could not
Then
take
you
proper
fell ill.
leave from the authority due to shortage of time.
No, then you fell ill.
Now, my lord, next paragraph. After coming home, he was posted in Katlijara, very near to his house, my lord. After coming home, I find my mother in a serious condition and there is none to look after him. I remain busy for her medical treatment and after her recovery, I myself become ill seriously. And now I recovered from illness.
Is there no authorized medical hospitals, centers
He further
in the
says, my
battalion?
lord, he further states, my lord, that I recovered from illness and now in a position to join my duty. If your honor would please me allow me.
Where are the medical reports?
Medical report, my lord, I have annexed this, my lord, representation, your lord.
Where is it?
That was sent by registered post, my lord, page 25 and 26 is the translated copy. And here, my lord.
Where is the medical report?
My lord, this is at page 26A, your lordship. You see, he has been
26.
suffering from melania, your lord.
26, there's only 26 and then 27.
And then 27, your lordship, there are some.
26 is the notice.
26, my lord.
27 is the last and final show cause.
26A, my lord.
There's no 26A here. Of the writ petition?
Writ petition, my lord. In my writ petition.
Yes.
Dr. Kinkor Pal, my lord, he was a my lord of the Karimganj civil officer. And he said, my lord, so suffering from melena yearly, blood goes to the stool, my lord, along with the stool, blood goes, my lord, that is melena, liver, this thing. With hypertension, it is pressure from 2014. So on 15/9/2014.
During the inquiry, did you produce all that documents?
I produced before the disciplinary authority along with my representation.
No, inquiry officer. Inquiry officer, did you produce all
My
this?
lord, page 24, disciplinary authority.
Who conducted the inquiry?
Inquiry by an assistant commandant.
So he's the inquiry officer, not the disciplinary authority.
No, I filed my reply before the disciplinary authority. Page 24. And exact 3. Prior to the inquiry, my lord, prior to the constitution of the inquiry, I submitted my reply.
What is your health condition now?
Now I am, my lord, on.
You're fit.
On 16/4/2015, my lord, I was, my lord, I said
No, now, 26.
Now
in the year 26.
Recovered from my illness.
Are you sure?
Yes, sure, my lord. He is coming to my chamber sometimes, my lord.
Oh.
So, my lord, then unfortunately, my lord, my mother made, my lord, fell ill. I could not save her, and I felt illness. I felt, my lord, myself well.
But in the inquiry, there is nothing, there's no reference to all these documents.
And that is the thing, my lord. That is the thing, my lord. Inquiry, and my lord, inquiry report I have shown to your lordship, page 38. Nobody has stated, my lord. None of the prosecution stated, not the, my lord, my lord, the inquiry officer has stated that this unauthorized action, my lord, was willful in my part, my lord. And that is to be stated, my lord. Appeals court said that is to be stated for removal, my lord. That facts that it is willful, it is to be stated in the inquiry report, and then, my lord, in the impugned order. Now, nowhere this has come, my lord. That's why, my lord, I was referring to the decision of Krishnakanta Parmariya law. Paragraph 17.
No, what is not stated in the inquiry?
It was not stated, my lord, that his unauthorized absence was willful.
It is there, the statements of PW2, PW4.
They said only I was absent. That's all, your lord. They said I was absent, that's all, my lord, but they did not say that it was willful enough, that, your lord.
How can they say? They are not your superiors.
No, my lord.
They can only say that you are absent.
My lord, it makes clear, my lord, your lordship may kindly see paragraph 17.
No.
Of this particular
in the inquiry report, there are certain witnesses who have come and deposed.
First court said that it must be stated in the, my lord, inquiry report.
It is stated. Where is your defense to say that this absence was not willful?
Lord, I
during the
said
inquiry,
that I
did you make a
that is my
statement?
defense. And if I fail ill, my lord, it will not be willful, my lord. If I fail ill, my lord, then it not be intentional.
This is what we want to find out from the inquiry report.
Now,
did you seek to examine the witnesses?
Nobody has said during the inquiry that my unauthorized absence.
Nobody can say that because they are not your controlling authority. This PW2 is Inspector AB.
No, inquiry officer is to say after conclusion that is willful. What the inquiry
because there is
officer
no
said,
defense.
What the inquiry
you did not bring out any evidence to counter the evidence of the department.
prolong unauthorized absence, my lord, what the inquiry officer said, my lord, from duty without any intimation to the authority and his negligence in responding to official notice and resuming gross indiscipline and negligence of duty. Demonstrated as she does not in any way meet the minimum standard prescribed to a member of the discipline force. So, my lord, I had to cite rely on a decision of the police force, my lord. And paragraph 17, my lord, I am reading your lordship. May kindly see for the time being.
So we will go to the judgments, Mr. Counsel. First, convince us of the facts that you had participated, you had put in all the efforts necessary.
I have participated.
These are matters, these only lay down the law. The law has to be applied on facts.
Now, in the inquiry report, it just your lordship could see I had participated.
You had participated, you did not raise any objections. Did you? Did you place all these materials before the inquiry officer to say that there are medical reports that you should be on bed rest, and therefore these are not willful absence? Where are these statements? Where is the appeal? Where is your appeal?
Inquiry report, there is nothing.
Where is your appeal?
Only my reply that I am.
Where is your appeal before the appellate authority? Page number.
Appeal, my lord. Appeal, my lord, your lordship will see page 52. With respect to Ramgun submission, I beg to state levy put the following three facts favor your kind consideration and sympathetic order. Dates are on 12th and so I submitted a letter before your honor with same facts but not yet get any response, and hence I further like to submit that honorable disciplinary authority Commandant so Hailakantri passed the order number so on 26/2, and both this order.
Where are the records, Mr. Ghosh? In personal custody of the additional AG.
So peculiar aspects of this matter, your lordship will find. Firstly, my lord.
We'll examine the records first.
My lord, period of unauthorized absence was regularized. Then for the same period, my lord, penalty was imposed. How it is possible?
We'd like to examine the records.
Right.
Matter be relisted again on May 28th.
28th, yeah.
The learned additional AG
My-
representing the state
My friend
is not available, nor are the records pertaining to the departmental proceedings are available. Under such circumstances, matter stands deferred. Yes,
My lord, on 28th, there may be a local holiday, my friend.
local holiday. If it is a local holiday, it gets deferred.
Eid, dear lord.
Then it gets deferred.
It will be on, my lord, sometime during the month of June, your lordship. Next week, after Eid.
All right, 4th of June. 4th of June.
My lord, I will be going back to Delhi, your lordship. My friend is there. My lord, I am now residing in Delhi. Your lordship.
That we have heard for the past 1.5 years,
My lord,
but it's nice to see you here in
I
court.
will be only coming back.
Why, what is so,
No,
it could be relaxing, but why are you so anxious to retire? When it's time to retire, you'll retire.
Ultimately, Lord, we have to go. Your
That's
lordship,
right.
today,
So therefore,
or tomorrow, my lord.
therefore don't be too anxious to
Difficulties
retire.
are there.
The institution wants people like you with experiences.
My lord, I am now 76 years old.
You're 76 years old. You're 76 years younger.
Better to retire, and I have decided only this year I will be coming.
I hope you reconsider your decision.
Life is coming to an end. Your lord.
Huh?
Life is coming to an end. It will come.
That is universal truth.
Okay, oblige, madam.
Yes. Yes.
Gotcha. So my lords, the precise issue lordship was in the last occasion was that the judgment of R.K. Rajesh Agarwal, so that was based on a vacancy based roster. Now, lordship, since there was a subsequent development of an office memorandum of 29/12/2014, bringing in the postings and the implementation along with the guidelines. So, lordship, pursuant to that, things have changed. So now, lordship, what is followed is a roster-based promotion. So, my respectful submission, lordship, since the position has changed, lordship, that judgment would not be applicable. Thanks.
Where is that judgment? Rakesh Agarwal.
Rakesh Agarwal. That is in the writ petition.
It is at page 80, 80.
Is having writ petition 4319 of 2021. There it is at page 76.
Malat, kindly take up the second 3565.
Where is Rakesh Agarwal?
Rakesh,
Where is the judgment?
Lordship, it's page 80. Annex
80, Malat.
80. Hmm. Notification dated 8/3/2013 was sought to be quashed.
Correct, your lordship. So
Now, after this, what notification are coming?
lordship, if my lord takes up my reply to that affidavit and opposition at page number 180, lordship. This is an office memorandum of 2014, lordship. Page 180.
118.
180.
180. Yes. This is 29 December 14.
14, lordship. Lordship, this is basically a replication of the Supreme Court judgment of R.K. Sabharwal, bringing in the guidelines for implementation of
What has happened to the earlier notification of 8/3/13? That was superseded.
Lordship, 8/3/2013 was the notification wherein Lordship this promotion was given effect to of Rakesh Agarwal's case. That was interpreted.
Okay.
And Lordships, this came subsequent. So Lordship, either the department or the Lordships in the judgment could not have applied this. So Lordship, that is what the position have changed subsequently. And that was a vacancy base, and now it is.
Please read it.
Lordships. Implementation of post-based roster, page 180, Lordships. Consequent upon the amendment made in the Assam Scheduled Caste, Scheduled Tribes reservation in vacancies and post 1978 and acceptance of recommendation of one-man commission constituted by government of Assam by notification number this and this, dated 24th of October 2013, with Sri Harish Sonwal, as the commission to study and acquire quantifiable data and backwardness of the scheduled castes and scheduled tribes, their inadequacy of representation in government services and posts, and impact in overall efficiency in public administration. Following guidelines have been prescribed in order to implement the post-based rosters reservation in matters of reservation of posts of scheduled castes and scheduled tribes, plains, scheduled tribe hills in direct recruitment and promotions.
preparation of roster 1.1, the appointing authority shall prepare the respective roster based on the principles elaborated below and notify the same with the concurrence of personal and welfare of claim tribes backward. Number 1.2 says all vacancy-based rosters shall now be replaced by post-based rosters. The appointing authority shall prepare a post-based roster for each cadre. While preparing the rosters, the appointing authority shall give effect to the reservation of posts for the scheduled caste, scheduled tribes, scheduled tribe hills as per the prescribed percentage of reservation as provided in Schedule 5A of the Act. So these are the guidelines to implement the post-based reservation. This came subsequently.
No, please read it. Let us understand this.
The prescribed percentage of reservation as per Schedule 5A, 10% to the STP, 7% to SC, and 5% to STH. Each category of post shall be treated as a separate cadre. The roster shall be prepared for each cadre depending upon the number of posts in the cadre as per the principle underlying the model 100-point roster given in the Schedule 1 of the Act. A format for preparing roster register for cadre having more than 13 posts is placed at Annexure 1. In case of small cadres up to 13 posts, the post-based roster shall be prepared on the basis of model 13-point roster provided in the Schedule 2 of the Act. Format for preparing roster register for cadre having less than 13 posts is placed at Annexure 2.
Is joint, what is the post now? Joint commissioner.
Joint commissioner. From deputy.
How many posts are there?
There are
5 posts.
less than 5.
No. 5 posts.
5 posts.
Don't give vague answer. Don't mislead.
The Lordship, then the next position, Lordship, there shall be no reservation in single cadre post. The roster are to be drawn up by each establishment keeping in mind two fundamental principles: that the reservation for the entire category maintained as per the prescribed percentage of reservation and the total reservation should be for STP, SC and STH in no case exceed 22% of the cadre. The number of points in each roster register shall be equal to the number of posts in a cadre. There shall be a separate roster register for direct recruitment and for promotions. The rosters are an aid to determine the entitlement of different categories with regard to the quota reserved for them in matters of appointment and promotion. They are not intended to determine seniority in the cadre. While a cadre is generally to be constructed as the number of posts in particular grade for the purpose of preparation of roster, it shall comprise posts required to be filled up by a particular mode of recruitment in terms of applicable recruitment rules. To illustrate, in a cadre comprising 100 posts, where the recruitment rules prescribe a ratio of 50:50 for direct recruitment and promotion, the roster for direct recruitment shall have 50 points, and that for promotion shall have 50, thus making a total of 100. Since reservation does not apply to transfer or transfer on deputation, where recruitment rules prescribe a percentage of posts to be filled by this method, such posts shall be excluded while preparing up the rosters. At the end of rosters, squeezing may have to be done for reserve categories to reach the respective number of posts to be reserved for them without violating the 22% for SC, STP, and STH limit in any cadre or group. Whenever there is an increase or decrease in the cadre strength, the roster shall be correspondingly expanded or contracted through government notification with the approval of Personnel and WPT and BC department. The same shall also apply whenever there is a change in recruitment rules which affects the proportion of posts to be filled by a particular mode of recruitment. Operation of rosters. At the point of initial operation of the roster, it will be necessary to determine the actual representation of the incumbents belonging to different categories in the cadre vis-a-vis the points earmarked for each category vis-a-vis SC, ST, OBC, and general in the roster. This may be done by placing the appointments made against each point of roster, starting with the earliest appointee. If the earlier appointee in the cadre happens to be candidate belonging to the scheduled caste against point number 1 of the roster, the remark unutilized by SC shall be entered. If the next appointee is a general category, the remark utilized by general category shall be made against point number 2, and so on and so forth till all appointments are adjusted in the respective roster. In making these adjustments, SC/ST candidates adopted on merit shall be treated as general category candidate. In case of small cadres up to 13, all the posts shall be earmarked on the same pattern as in the post-based roster. Initial recruitment / promotion against these points shall be by the category for which the point is earmarked. Replacement of incumbents of posts shall be by rotation as shown horizontally against the cadre strength as applicable in the model 13-point roster provided in Schedule 2. While operating the relevant roster, utmost care shall have to be taken to ensure that on no occasion prescribed percentage of reservation of 22% is exceeded. If such a situation occurs at any time, that prescribed percentage of reservation exceeds 22%, then the relevant unreserved point occupying as a result of rotation shall be skipped. While operating the roster, persons belonging to communities for whom reservoir has been made, but
come back to point number 2.2.
Lordship.
Please explain how how this is to be operating.
Lordship. In this regard, Lordship, may I take my lords to the annexure which has been mentioned here. This roster of L sheet, annexure 2, there is another writ petition of 2021.
Is it available in the rules?
In the rules also, yes.
Yes. It is
There.
in the rules.
My yearbook, it's 263 page number. Assam Service Manual.
Scheduled caste and scheduled tribe.
Lordships.
Rules or act?
Lordship, this is the Act, Lordship.
Act.
It is provided in the Act. Page 263.
6.3.
Schedule 2, Lord.
Model 100. 100 point.
Just below that.
Schedule
Lordship. Schedule 2 is below that.
Less than 13.
Less than 13. Lordship.
Okay.
Model post-based roster for cadres having number of posts 13 or less than 13. The roster showing 9 posts with 1 vacancy, that is the 10th post, going to STH will always give a percentage of 30 for reserve categories. Slight variation at 1 or 2 points is inevitable for maintaining the prescribed percentage of 22%.
You're reading from?
Lordships, this schedule 2, Lordships, just below the line, Lordships.
Okay.
Ends with post
Now
of 13,
from this chart, you tell us how it is to be filled up.
It will be filled up as if
Now you need this. This is how many posts? 5.
Here it is 5. So
5.
Lordships,
5. Okay, show us how 5.
So Lordships,
Initial recruitment 5.
Lordships.
5th is the STP.
Fifth is the STP.
Then
my lords, after 5, the next roster 6 will start. That will be for the general category candidate. 7 will be for again a general. 8 will be for the SC. 9th again general. 10th again general. 11th, 12th, 13th. But if the 14th point again starting will go to the STH hills. And Lordship, it will go in a rotation. Lordship. After 14, again 1, 2, 3, 4, 5. Those posts which are earmarked will be replaced by the person of the respective categories.
it is not clear from the chart.
Lordship, it is how they implement because they have to follow a book of rosters, Lordship.
So that's
And
what we are
that
asking
is
you. You
correct.
tell us, you explain to us from the chart how it operates.
Lordship, these
So first is the cadre strength.
cadres,
Now in your case, the cadre strength is of 5.
5.
So beyond 5, it doesn't go,
Lordship.
right?
Lordship.
So initial recruitment would be these 5 posts.
5 posts.
The 5th is the STP.
STP.
Right.
So
Then
once it is earmarked for STP, Lordship, here the theory of replacement would come in. Lordship, I'll take my lord to that act also. That shows that once a roster is filled up, thereafter, Lordship, it will not continue as a running error. It will go by replacement of the person from the respective categories. Supposing, Lordships, here the fifth post is vacant by retirement or through promotions. Fifth point falling vacant will be now filled up by a person of that respective category. So, Lordship, if it is for the general, if 4 of them are general and 1 is STP, he will get a post of STP on the fifth roster. If the roster points are 6, 7, 8, 9, and 10, here, Lordships, it's not for STP. Only a SC candidate falling under 8 number post will come. Now it goes on replacement. Once the posts are filled up, each category, so that the required percentage remains the same. That is how the roster is. Basically, Lordship, it will be the vacancy of the rosters which are vacant, and that has to be refilled. Point of rosters, in fact. Lord, may I continue with this 180?
Yes.
Operation of roosters. But 181, 2.35 maybe. But do I need to read 2.2 again for that clarification of the axiom? So I'm coming to 2.3. While operating the rooster, persons belonging to communities from where reservation has been made but who are appointed on merit and not owing to reservation should not be shown against reserve points. They shall occupy the unreserved point. After completing the adjustment, as indicated above, a tally should be made to determine the actual percentages of representation of appointees belonging to the different categories in the cadre and determine if there is any shortfall of reservation in the cadre. 2.5. Shortfall of reservation of a particular reserve category in a cadre means the difference between the total numbers of reserve posts for that category in the cadre and the number of persons of that category appointed by reservation and holding the post in the category. Backlog vacancies of a category and those vacancies when were earmarked reserved for that category in an earlier recruitment year but remain unfilled in the previous recruitment attempt on account of non-availability of suitable candidates belonging to that category are and still lying unfulfilled. The appointing authority shall calculate the shortfall of reservation as well as backlog in every category and initiate action for filling up the same first before filling up current vacancies of posts. After all shortfall and backlog of reserve posts being filled up, the post-based roster shall operate on the principle of replacement and not as a running account as hitherto. In other words, the points at which reservation to different category applies are fixed as per the roster and vacancies caused by retirement, etc. of persons occupying those posts shall be filled by appointment of persons of the respective categories. To illustrate, if a vacancy caused by retirement or promotion to the point occupied by STP, the same shall be filled by the STP candidate. The existing backlog vacancies shall be considered as vacancies released by recruitment, resignation, promotion, etc. of the persons belonging in the reserved categories, and the same are to be filled by appointment through direct recruitment or promotion as the case may be from the respective categories by special drive so that prescribed percentage of the reservation is maintained. Access, if any, would be adjusted to future promotions and the existing appointments would not be disturbed. Lordship, this is on merit and the other is for de-reservation. Lordship, de-reservation has been done away by Supreme Court in full with the policy. Now, Lordship, that cannot be the de-reservation.
De-reservation is not an issue here.
Not at all. Because it is only de-reservation, Lordship, the issue would be if there is a shortfall of the earlier vacancies. I might have been promoted on the earlier vacancies. That is a separate issue, not connected with the issue at hand.
No, so how does it alter the position as held by the coordinate bench?
Lordship, in that
Oh.
judgment, Lordship, it was a vacancy based. Lordship, there at that point of time, it was the number of vacancies on which the percentage was applied. So, Lordship, if there were 5 posts, irrespective of which post goes to which person, Lordship, now in the present context, it will be the post which has already been earmarked for that particular category. So, Lordship, here the percentage criteria of being of single post or having that percentage applying on that person, Lordship, that would be immaterial now. Lordship, it is now only the earmark post, whether it was for the STP, because Lordship knows it very well, as I've read, Lordship. Now, different categories cannot be replaced with another. If it is a general category, it will always go to the general. And if it is for an STP, who has come by retirement or promotion, it will go to the respective categories. That is.
So,
Thank you.
So, Lordship, in this regard, if I may invite my Lord, Lordship, I've given a compilation of the judgments, wherein below the division bench of our High Court has upheld the 29/12/2014 office member. Lordship, that judgment compiles of 5 judgments.
what is 29?
29/12/2014, the office memorandum which we have just read, Lordship, that is operation and implementation of the rules.
Okay.
So that has been upheld, Lordship. I just wanted to draw my Lord's attention on that.
Yes.
Lordship, we have IV Gauhati, that is at page 66, Lordship, division bench judgment of our High Court. Lord. It starts at page number 66. And my Lord, they come at page 86, para number 33. 33 and 34, page number 86 of that compilation.
You are referring to the compilation.
Lordships. That is it. I've given the compilation of 5 judgments. Yes, last year. So, Lordship, judgment number 4 is IV Gauhati Dasgupta versus State of Assam. Lordship, if I may invite my Lord at page number 66, that is the judgment. The relevant page would be my Lord's page 86. Only 2 paragraphs.
Page number
86, Lordship. 86. Lord. Para 33. Various office memorandums were dealt by the division bench of this court. So, Lordship, this 29/12 as well was also indicated here. Lordships. Para 33, if I may read.
just 1 minute. Mr. Bora and the ONGC, sorry, Numaligarh. I think we'll not be able to take up your matter today. We'd like to refix on 9th of June. Yes, we said, but
They were supposed to submit documents.
whatever it is, we'll take it up on 9th of June. Is it convenient for all the council? We are giving you 9th because we have lesser matters, so that we can give you, can finish off the matter on 9th, if possible. Yes, 9th. 9th of June. Tuesday. No, let it be on 9th. We'll start on 9th. Therefore, we are giving it on 9th. If we can't complete on 9th, we'll finish up on 11th.
On 9th, I've got another matter fixed, my lord. Can it be on 7th or?
No, 7th.
7th is a Sunday, I think. 7th is a Sunday.
So let it be on 9th because we'll try to accommodate the council, let him complete. If possible, we'll finish off. Otherwise, we'll try to finish off on 11th.
What's the document that are supposed to submit?
If they don't submit, they don't submit. We'll pass orders, consequential
They
orders.
were supposed to submit. If I get today, then I will get it.
You submit whatever documents are
We
there.
have to got nothing to submit.
Last occasion, they were deferred the matter by mentioning that they were going to submit.
We'll pass orders to that effect. If there's anything recorded in the last, we'll pass orders. We just did not want you to wait until the court rises because we thought we'll take up this matter on today, but because of all these matters become difficult.
Why not? Why?
No, we are not rising. We are only mentioning this because he's a petitioner in person.
All right.
All right, 9th.
This matter repeatedly get on. It's a very urgent matter.
I know, urgent, but
If possible, Lordship, can we give us a next week by Friday or Thursday or
if we want on Thursday, we can have it on Thursday, but there are already 16 matters.
this honorable court already considered my matter and already ordered to this the matter.
Let us have it on 2nd then. 2nd. There are 7 matters, but we'll try.
2nd?
2nd of June. Right? This item given as
25.
25, we pass orders. 2nd of June. All right? Please inform the amicus also.
Yes.
If possible, Lordship, kindly mention that my matter.
Yes, at 2 p.m. At 2 p.m. We'll take it up at 2 p.m. Item 24. Second. Yes, continue.
Lords, page 86, para 33. In other words, the purport of the office memorandum dated 29/12/2014 has to be understood that it was issued consequent upon the amendment to the Act of 1978. As noted above by the Assam Act 19 of 2012, the Act of 1978 has been amended.
So you are reading the judgment for what purpose? To show that it has been upheld.
That has been upheld.
Is it disputed?
Judgment. No.
Not disputed.
Then I'll leave it to
Then?
Then, Lordship, one judgment that covers the other issue involved in my lords, that the 18/1/2023 office memorandum will always operate prospectively.
This is over and above the judgments you are relying on.
Relying, Lordship.
Why?
Lordship, this is only for the purpose because here WBC 130 of 2016. Lordship, here the issue was that same issue, Lordship. In fact, the person wanted a seniority based on the earlier cadre. Wanted that this operation of 18/1/23 should be given a retrospective effect by promoting him to the post where he was brought down. This judgment says that no, it will have a prospective application. Para 12 takes note of that relevant factor. So the prayer made by the writ petitioner over here that the earlier promotion has to be disturbed, Lordship, in terms of this judgment, that the subsequent development of 18/1/23 has come in. Only subsequent to that, the department can take a call of changing the cadre positions.
I've not understood.
Lordship.
This order is for what purpose?
Lordship, 18/1/23 was a subsequent office memorandum, which brings in the catch-up principle. So, Lordship, most of the departments have taken a call to change the positions by taking the retrospective. So, Lordship, this judgment clarifies that only the application of the office memorandum 18/1/23 of bringing in catch-up principle will be prospective in nature. So, Lordship, the earlier position of whomsoever was there in the cadre, his seniority was not interfered by. So that is what the judgment says. So
basically, Lord, what I'm saying, that 18/1/23, now the challenge in this subsequent writ petition of 2023 is on the basis of a DPC meeting. Allegedly, what has been stated that it is not in consonance with 18/1/23 as well. So, Lordship, the authorities can very well take a call on that 18/1/23. They can reshuffle, because I have not challenged it's 18/1/23. Lordship, the authorities may take a decision. That is-
Yes, Mr. Following 18/1/23, COT has been hearing, the petitioner has been placed in serial number 2. And the private respondent, my friend is representing, he's just serial number 3. Seniority has been restored, so far as the petitioner is concerned. I've got the copy.
My lord, there is
There's
no
no dispute regard, this is a subsequent development.
My lord, kindly consider the affidavit filed by the department. In the selection process itself, they place the writ petitioner above the private respondent. And thereafter, they consider that roster point 5, according to roster point 5, the private respondent will be accommodated. Kindly come to 327 at annexure 17. Affidavit filed by the finance man. 327. Kindly come to serial number 4. Men in position at present 1 and existing vacancy 4. Now, next page, Bandar. The roster point, clause number 5, the roster point of the existing vacancies fall at RP number 4, unreserved, RP number 5, STP, RP number 6, unreserved, RP number 7, unreserved. Now come to clause number 6. There are 8 numbers of officers under zone of consideration as per the latest web, my lord, of personnel department dated 18/1/2023. While preparing the minutes, that departmental promotion committee has considered the web and accordingly placed the writ petitioner above the private respondent. So they maintain the seniority as per 18/1/23, but they deprived the writ petitioner by wrongly following roster appointment, which is kindly at clause E, my lord. At page 329. The committee discussed the Honorable High Court judgment dated 31/3/2016 in WPC number so-and-so Rakesh Agarwala, wherein the Honorable Court had directed that the promotion from Deputy Commissioner of Taxes to Joint Commissioner of Taxes shall be carried out on the basis of recruitment rules in force without any additional weightage on reservation as provided under the Reservation Act as amended. The members of the committee also produced the matter in view of OM dated so-and-so, dated 3/8/16, along with the latest OM dated 18/1/23. Now, my lord, kindly come to F, my lord. Further, the WPT and BC department has also viewed number 5, number so-and-so to continue following reservation provision as in 13-point roster on rotation basis in the cadre of Joint Commissioner, subject to maintenance of reservation within prescribed percentage of 22%. Representative from Tribal Affairs Department affirmed the committee that
department should follow 13-point roster on rotation basis in the cadre of Joint Commissioner of Taxes. Say this department selection committee, they overrule your lordship judgment. And the WBC department, they also overrule the
Which judgment? The Rakesh Agarwal.
Rakesh Agarwal.
No, but Rakesh Agarwal is a judgment prior to the notification.
Which
so the
notification?
notification.
My lord, that is misleading. I'll come to that, man. What my learned friend is providing, placing before your lordship, only misleading.
No.
What is this, my lord? Kindly come to Annexure 6.
See,
My lord, I
come to page number 328, serial number 5.
Serial number 5.
Yes. Now, this, if you compare with this rooster chart under the Act of the rules, the 13 point, it appears to be that they are following the initial recruitment, or at least that is how the rooster point appears to be so.
No.
RP4 is unresolved. RP5 is STP. RT6 and 7 is unresolved.
Yes, sir. My lord, the Rakesh Agarwal's judgment is clear that in the cadre strength of 5, there cannot be any reservation imposed. And that is a clear case wherein the roster point of the Joint Commissioner was challenged. Kindly come to page 80 again, my lord. 80 of my report. Kindly come to 81, which is the first paragraph of the judgment. What was under challenge in this writ petition is this, my lord. By filing this writ petition under Article 226 of the Constitution of India, petitioner seeks quashing for notification dated 8/3/2013 issued by the Commissioner and Secretary to the Government of Assam Finance Taxation Department, laying down post-based roster in the cadre of Joint Commissioner of Taxes under Finance Department, and further seeks a direction to consider the case of the petitioner and other eligible candidates in the cadre of Deputy Commissioner of Taxes for promotion to the cadre of Joint Commissioner of Taxes without applying the principle of reservation. My lord, this first paragraph will clarify what was under challenge. Post-based roster. What my learned friend is submitting before the court. How he can submit that? A young lawyer, how he tries to mislead the court. It's post-based roster. This judgment is applicable to post-based roster. What he is submitting, man. Very sad. The first paragraph of the judgment itself, it speaks clearly that yes, my lord, this judgment is applicable in the post-based roster, not vacancy-based roster. Where from he brings that concept, I don't know. This judgment is not applicable. How he can send that without going to the judgment? Anyway, man. The law is, the first paragraph is itself said that 13-point roster, post-based roster was under challenge in the instant case. Then my lord, I will place again two judgment, my lord. Kindly come to paragraph 21 of the judgment. This now brings the question as to whether in a cadre of 5 posts, 1 post is required to be earmarked for STB having regard to the percentage of reservation provided to such category 10%, which works out to 0.50. Now come to paragraph 23. In Khanindranath Chaudhary versus State of Assam, reported in 2007 for GLT, a single bench of this court was confronted with the question as to whether in a cadastre of 4, there can be any reservation for the reserve categories as per the percentage provided under the Reservation Act. After referring to various decisions of the apex court, this court held that the principle that in a single post cadre reservation at any point of time on account of rotation of roster would bring out about a situation where such posts would be kept exclusively reserved for the members of the reserve category or to the total exclusion of the general category would be equally applicable to a case where cadre strength is 4. At this stage, the decision of the apex court in RS Guard, I'll place that judgment. RS Guard may be noticed. That was a case where under the Reservation Act 20%, 1% was reserved for SC. The cadre under consideration had 6 posts, but the existing roster register provided 2 roster points for SC categories. The apex court held that if the roster was to be followed, 2 posts would be reserved for SC categories candidates which would exceed the reservation of 21%. My lord, here, my lord, 22%. Out of that, my lord, STP is 10%. Point, it cannot exceed that 10%. If 1 post is reserved for STP, it will then STP's percentage will be 20%, which is not permissible. How, my lord, apex court held that? Apex court held that court is not concerned with the reasonableness or otherwise of the percentage of reservation. If 21% of post has been reserved for SC, the roster point for SC cannot exceed the pool. This is the reply. Roster point cannot exceed the reservation as provided in the Act. My lord, I'm placing again section 5 of the Act, my lord.
Yes.
Reservation for scheduled castes and scheduled tribes in posts to be filled up by promotion. Reservation for members of scheduled castes and scheduled tribes in posts to be filled up by promotion in any establishment shall be regulated in the following manner. There shall be reservation at 7% for members of scheduled castes, 10% for members of scheduled tribes plain. Here, my lord, the private respondent is STP is 10%. My lord has taken this book only, my lord.
Yes.
Now, kindly see one more thing I would like to place. Here, my lord, 5A, manner and procedure for giving effect of reservation. This was inserted, my lord, by Act of 2012. Below, your lordship will get inserted new section 5A 2. Well, kindly now come to page 263 of that book. What my learned friend has relied upon, I am relied upon the same thing. What is saying, my lord? Schedule 2, section 5A. Model post-based roster for candidates having number of 13 or less 13. This is the model post-based roster. What he is saying that by Act of 2012, my lord, post-based roster has been introduced. Kindly come to Annexure 6. Of my writ petition at page 49. Get the Assam Gazette notification, 24th August 2012, my lord.
What is the amendment?
My lord, by this amendment, section 5A was introduced. And kindly come to page 57. That is schedule 2. This is the model post-based roster for cadres having number of posts 13 or less. It's a model post-based roster. The very word is post-based roster. It was introduced in 2012. My lord, this sort of misleading statement, I'm very sorry to say, not
Like,
expected.
What is the effect of the subsequent notification?
My lord, in 2012, the act was enacted, and although 2014 there is another notification, but the act has come into force in 2012 itself. Now, my lord, kindly come to one more thing, my lord. I got my promotion in the last part of 2025, but why they have kept a post for the private restaurant from 2023, and by the selection of minutes dated 4/2/23, which is at page 327. I have furnished that ITI reply. My lord.
What is it that you want to show from 327?
In the ITI reply, they have
What is your name?
My name is Santanu Dharma. They recommended which their recommendation at page 330. The committee accordingly considering the relevant aspect, my lord, aspect recommended the following officers for promotion to the cadre of Joint Commissioner of Taxes from the cadre of Deputy Commissioner of Taxes, subject to leave of the Honorable Gauhati High Court as may be necessary. Here, my lord, serial number 4, Kamaleswar Lahiri, SGP. In case of Sri Kamaleswar Lahiri, who has been recommended for promotion against RP number 5. Here, my lord, they recommended the name of private respondent on the basis of roster point number 5 and due direction of the Honorable Court that promotion would not be made to him without the leave of the court. The committee has advised the department to take up the matter with the Honorable Gauhati High Court and comply with its direction. Now, my lord, kindly see the RTI reply. Which I have already furnished. my lord. Here, my lord, kindly come to RTI reply page 2. Recently, at the bottom, my lord, of page 2. Presently, a single post has been kept vacant due to Honorable Gauhati High Court order. My lord, your lordship has passed the interim order to the effect that without taking the leave, the private respondent may not be appointed. There is no order to keep that post.
But unless it is kept vacant, in the event there is an alteration, how will
My
the
lord,
promotion be made?
that is
So it's a natural consequence.
my lord,
He is selected, did not interfere with his selection. So therefore, only thing is that the promotion should not be given effect.
yes, my lord.
The post has to be kept vacant.
Yes, my lord. I am again coming to page 80, my lord, of my leave petition. Only relevant at page 85. In Devakumar Dotto, this court, after taking into account the
You're-
state
You're reading from?
page 85, para 25
Oh,
of the leave petition.
well, you are
My lord, sir.
asking us to go from page 20 to 330 and then
My
coming
lord.
back to 80.
Very sorry.
No, you don't have to be sorry, but tell us.
Yes, sir. Yes,
what
ma'am.
is your grievance here?
Yeah, 85 of my leave petition, my lord. Paragraph 25.
25. Yeah.
Upon severe judgment, my lord, this foundation of Rakesh Agarwala was passed. In Devakumar Datta, this court, after taking into account the statutory percentage of reservation for 3 categories, that is SC, STP, and STAs, held that in the cadre of additional chief engineer in the water resource department, having cadre strength of 7, 10, and 5% would come into 0.049, 0.70, and 0.035 respectively. It was held that no post could be reserved for any of the reserve categories candidate in the said cadre as it would exceed the prescribed percentage of reservation provided to each of the reserve category. Now, my lord,
Yes.
then my lord, kindly come to paragraph 26.
Ratio of the judgment is at page para 28.
My lord. Therefore, though logically 0.50 should be rounded off as 1, the peril in doing so would be that it is to be taken to be so. It would result in exceeding the percentage of reservation for STP statutorily fixed. Earmarking one post in the cadre of 5 amount to 20% reservation. Whereas under the statute, the percentage is 10. That being the position, the rounding of principle may not be applied in a case of this nature, as the application of such principle would lead to violation of statutory percentage of reservation. And kindly come to once again paragraph 26, ma'am. Here, my lord, there is a division bench judgment on this point. That judgment has been referred. It appears that against the aforesaid decision of Devakumar Datta, a writ appeal was preferred in the case of Pavitra Hazarika. The division bench not only upheld the view taken by the learned single judge in Devakumar Datta, but also held that clubbing together the entire percentage of reservation of 3 reserve categories for the purpose of finding out the quota of reservation fixed in a cadre for the purpose of promotion is wholly not permissible. Even if all the 3 categories combined, even that is not permissible. The division bench agreed with the view taken by the single bench that percentage of reservation as envisaged in respect of reserve category under the relevant statute can only be determined the extent
But
of
now state says that the seniority has been restored.
my lord, the seniority has been restored. If he
Who is at number 2?
Number 2 is the, my lord, petition
Petitioner. And number 3 is the private respondent.
in the post of DCT. That has been, my lord, corrected. But, my lord, in the first writ petition, that is of 2021, the promotion of the private respondent, the post of DCT is under challenge. So that will have to be, my lord, looked into by the honorable court first, because the post of joint commissioner
I am coming
is a
to
subsequent promotion
I am coming
from the post of DCT.
I'm coming to
But if the DCT order sustains, or, my lord, if it is interfered with, the entire scenario will change, my lord. That has not been addressed, my lord. From the very first day I am saying, my lord, that will have to be addressed first. From DCT to, my lord, the joint commissioner will come. Now, my lord,
What is the grievance in the DCT?
my lord, same, my lord, Rakesh Agarwal's case has been relied upon.
So
Yes.
DCT, who has been promoted?
My lord, the private respondent has been promoted prior to the writ petition.
as DCT.
No. Or it's in the same 2019, all were promoted. Yes. All were promoted.
Then why
No,
are you
he's there.
challenging? Why are you challenging? What are you
My lord,
challenging?
in that writ petition, I have challenged the Gedison list. While after hearing that, your lordship granted the interim order.
No.
My lord, let me clear.
Challenging the gradation list and subsequent thereto, both the parties were promoted.
My lord, no. After promotion in the year 2019 to the post of Deputy Commissioner of Tax,
He was placed higher.
he was placed higher. Then I challenged the gradation list. During that challenge, my lord, in the year 23, they promoted, they recommended the promotion of the private trust. During pendency of that case, Then I filed this 23. Again, another interim order was passed for protecting my interest.
Now, where is the seniority restored in the error of DCT?
Yes, madam. As per
DCT.
2023.
Now, now
So therefore, 21 writ petition.
That grievance is, oh, my lord, that.
There's nothing there.
Nothing.
my lord, my lord,
In 21.
in 21,
In this 4319.
my lord, Buddha repetition can be disposed of. Yes, ma'am.
Is a different issue. But
Yes.
in 4319, you're challenging the gradation. That is no longer an issue today.
Ma'am.
And in the subsequent writ petition, you're already protected by an
No,
interim order.
No.
No.
In the yes, ma'am. My interest has been protected.
Then
No, the protection was to the extent that, my lord, the private respondent will not be considered for promotion to the next higher level, that is the joint commissioner. Oh, my lord. And in 2025, he got the promotion to the next level. That is joint commissioner of tax. Now he has been promoted to the next level also.
joint commission.
Yes.
What is the dispute?
Yes,
My lord,
the seniority, my lord, has been restored.
my lord, dispute is this. In 23, I should have been promoted, my lord.
You are asking for the retrospective benefit.
My lord, kindly consider wrong by wrongly given following the
What are you claiming here, Mr. Counsel?
My
That's what we are asking you. Why can't you give us a straight answer?
my lord.
In this 4319, you challenge the gradation list
Gradation.
on the ground that he was promoted to DCT. And after being promoted, he's at a higher position. So that has been rectified.
Rectified.
So there is no grievance in 4319.
My lord.
In the subsequent writ petition, you are challenging that his promotion to the post of joint commissioner should not be granted.
My lord.
So although promotion granted, he is not allowed to join.
My lord.
You in the meantime have been promoted.
My lord.
So what is the seniority position in JCT? I'm sorry, yes, joint commissioner.
The joint commissioner, my lord, gradation list have not been prepared because, my lord, in 2025, he has been promoted. Private respondent is yet to be promoted because there is a stay operating. Minutes is of 2023, so far as the, my lord, private respondent is concerned, for promotion to the post of joint commissioner. So, my lord, that part is, my lord, stayed by the honorable. Others have got the promotion.
What
My lord,
exactly is the interim order?
Yes. The grievance of the petitioner lordship is for a moment page 327 of WPC, 35665 of
So, well,
2000.
one minute. We are trying to find out. The promotion is not to be notified.
Yes.
That is the interim order.
Yes, my lord. Yes.
Not to be notified.
Not to be
No,
notified.
my lord, it has been already considered by the
Considered.
petition. So, lordship will see, my lord, 327 page of the, my lord, 2023 report. Why is agreed by this, by the, agreed by the writ petitioner. 327.
Yes.
Lordship will see at the top, minutes of the departmental selection committee meeting held on 4/2/2023 for recommendation of candidates for promotion to the cadre of Joint Commissioner of Taxes from the cadre of Deputy Commissioner of Taxes for the calendar year 2023. The petitioner is agreed because Lordship will see now, my lord, in the next page 328, para 6.
Yes.
There are 8 numbers of officers under zone of consideration as per the latest OM of Personnel Department dated 18/1/2023, namely so and so. Here, Lordship will see, my lord, serial number 6
Yes.
is the writ petitioner. Serial number 7 is the, my lord, private respondent. So, petitioner was taken into the zone of consideration at that my lord DPC.
Petitioner was placed above the private respondent by following OM dated 18/1/23. That is clearly written
Yes, yes,
at
yes.
clause number 6.
That has been, that's why rectified also. Now, my lord, Lordship will now turn to my lord page 329. After the chart, my lord, at the top, no departmental proceeding is pending or is contemplated against the officers under zone of consideration. Now, next para is important. ACR of the last consecutive 5 years of Amitabh De, Santanudar, that is the petitioner hearing, and 3 Deepak Keot are not available with the department. Now, D, they have only considered, my lord, this 8 here, without, my lord, taking into consideration the case of the lead petitioner on the ground that, my lord, his annual confidential reports are not available with the authorities. So, my lord,
My lord,
yes, Lordship
my,
will see.
my lord, kindly see.
I'm pointing out that factual part. Point out.
I will give the reply.
Page 330, Lordship.
Let him complete.
I'm pointing out why the lead petition has been filed. 330, Lordship will see. Finally, my lord, these are the 330, my lord, para I.
Yes.
These are the 3, my lord,
four
persons,
officers, four
officers who have been recommended for promotion to the post of Joint Commissioner of Taxes. Serial number 4 is the private respondent. Pursuant to the order passed by this honorable court in the present lead petition, this particular promotion or recommendation was kept on hold.
Not notified.
And my lord, out of 5 posts on the day of my lord, this DPC, only 4 posts were available. So 4 were recommended. Thus, I'm placing the facts. I'm not arguing favor or against the petitioner or the private respondent.
So essentially what you are saying, the grievance of the petitioner.
Yes, it should be promoted from 2023. That is his grievance.
If at all,
Yes.
against these minutes,
Yes.
arises because his case was not considered as the last 5 years ACRs were not available.
That should have been his grievance, my lord. And my lord,
This minute has not been furnished to the petitioner in spite of RTI. Only they after they have filed the affidavit, my lord, only we came to know this is the minus one.
And page 327, Lordship will see para 3, my lord, just 4 on factual part. Man in position at present is 1, existing vacancy is 4. So, my lord, 4 were considered. Out of 5, that is a cadastre.
Now, in the meantime, he has been promoted.
Here, my lord, here now. In the meantime, probably, my lord, the vacancies have arisen. So, my lord, he has been promoted in 2025.
So why the promotion of the private respondent should be kept on hold? It's a question of
My lord,
vacancies.
it's a question of seniority.
my lord, kindly consider one. This
You are now promoted. You are also promoted. Your only dispute is with regard to who is going to be second. For that reason, why the promotion is required to be kept on hold.
My lord, kindly consider one thing. I have categorically stated in my additional affidavit that I have no grievance if a fresh consideration has been made. My lord, kindly one thing, my lord. What cannot be do directly.
We are trying to understand your grievance.
Yes, my lord.
We are trying to understand your grievance to the extent that what is your grievance now post your promotion in keeping the promotion of the private respondent under whom? You are already promoted to that post.
My lord, I placed the RTI decline. I placed the RTI decline.
No, your grievance is with regard to the inter se seniority.
My lord, kindly consider.
It is not a case that you are yet to be promoted.
No, kindly consider one thing, my lord. If this recommendation is allowed, that is against the law laid down by your lordship, in catena of judgment, there are 5 or 6 judgments I have placed, including the judgment of the Supreme Court. This selection is contrary to the law written by your lordship.
But
So,
your
so
ground for
this selection
challenge-
should go.
Your ground for challenge
Yes.
will arise only when you say that your non-consideration on the ground of 5 years ACR not being available is incorrect.
Yes, madam. That is,
But
they
that,
have not placed, I don't place the ACR before the authority. They have not placed the ACR. Why, my lord? That is best known to them, my lord. I cannot place the ACR before the selection committee. That plea they cannot take.
no, but it is there in the minutes.
My lord.
Unless you say that the ACRs were available.
My lord, ACR, ACR is not with me, my lord.
No, it is not with you. But
Yes,
have you
madam.
made an inquiry to find out whether 5 years ACR on the date when it was sent for consideration was available? That is the ground. The rest of the arguments you're making will come later. First, your non-consideration is on the ground the ACRs were not available.
My lord, in spite of my...
Now, if ACRs are not available, it's correct, then where is the fault of the respondents in considering the officers whose ACRs are otherwise available?
My lord, it is the duty of the department, my lord. It is the duty of the committee, my lord, to bring all the ACS.
Correct.
My lord, it is not the duty of the...
Is there a that
Let them file affidavit, my lord. Why it was not before the selection committee? Let them file affidavit.
First of all, let him place the pleadings in the writ petition.
let what do you call the agenda to the meeting minutes, agenda to the DPC. That will reflect how many officers and how many ACRs and what rank and
So that lot
will be available somewhere.
Well, para 6 says so. 8 were considered. Out of that, 3 ACRs were not available of 3 my lord, in respect of 3 my lord employees, officers. Lordship will see para 6, 8 numbers of officers under zone of consideration. This is one agenda. Then, my lord, after the chart in para C, part of para 6, C says, my lord, ACR of the last consecutive 5 years of Amitabh De, Santanu Dhar, petitioner, and Deepak Keud are not available. Now, my lord, on that day, my lord, if the ACR is not available, where is the question of considering the case of the writ petitioner? One. Secondly, my lord, even if we follow Rakesh Agarwal, then also, my lord, the private respondent will come in, my lord. Say, my lord, ST reservation cannot be followed. Then also he will come in because the ACR is available. And he will automatically be considered because since, my lord, the petitioner is not there, he will come above him, my lord, now. He's out of the zone of consideration. Out of 5, my lord, if 3 goes, automatically he will come in, my lord.
No, his case is that this reservation of
Say, my
STB
lord, there is no reservation, not followed. Then also, my lord, the petitioner goes and 2 more incumbent goes out of, lordship will say para 6, out of this 8. 3 goes. Yes.
4, 5, 6 are gone.
Amitabh De, my lord, Amitabh De, Santanu Dhar, and yes, 5, 6, and 8 goes.
5, 6, and 8.
Yes. Now, my lord, it will be confined to.
What has happened to 4? Although he is not before the court.
Well, he got the promotion.
He was promoted.
Yes, promoted. Subsequently.
No, here it is not there.
No.
Subsequently, another DP was held, Department Promotional Committee meeting was held and he was promoted. Petitioner's case has been considered in 2020, subject to ability of vacancy. Why I'm saying is, my lord, even, my lord, following Rakesh Agarwal, the petitioner is not under a zone of consideration because the ACRs are not there. And that aspect has not been put to challenge. No pleadings there to that effect.
How I can do that?
No, even after the pleadings are there, brought on record, you have your appeals,
there has to be a
your
challenge.
basic ground for challenge, basic ground for rejection, non-availability.
Yes,
of
well,
agent.
on that matter, if necessary, I will. And
Now-
and kindly pages, my lord,
Is there
order
any-
dated
Is
10.
there any vacating petition here?
My lord,
Any vacating petition you file?
What's it? I has been filed.
IA,
What's it?
for what?
In 2021 matter. There we have filed a vacating application.
But what I would pray, but today, if at all the new pleadings will be filed, while post is available, the private respondent, my lord, let this honorable court allow him to join. The seniority will be, my lord, determined, my lord, subsequently in the writ petition.
No, that is what we are asking you, whether
Yes.
any, what is this order?
my lord, kindly pages that order.
Because we want the officer, only 5 is
Here, my lord,
post is there,
here,
one
my
is
lord, the respondent were asked to
In
bring
which
the
matter?
instruction, my
In
lord.
which matter?
In the present case, my lord, kindly see the order dated 10/3/26.
This has nothing to do with the
My
query
lord,
raised by the honorable court.
It is the court order, my lord. Kindly see the order sheet, my lord, of 23 case, my lord, 35/26, 35/65.
It was on that day that argument was made, so honorable court sought for a clarification. I have it, my lord. Whatever is there in para E and F, my lord, that is my instruction. Is already there in the minutes. Today, my lord, I have placed before the honorable court that the writ petitioner was not considered because of non having the ACR before the committee.
Then now is there a vacating petition?
No, my lord.
Like so.
In 23, there is no vacancy.
4319, there is 194 per person. That was 5.510.
4319 is already becoming infractuous today.
But there is a vacating application because there was a stay order in that petition.
We are asking you whether there is a vacating petition here.
Consequent 23 was.
Then it is not there. Not there. If you advise you, we are closing this petition 4319.
4319.
Third counsel for party, this petition was filed by the petitioner seeking a direction. For interference or notification number so and so dated 31/10/2019, whereby the private respondent was promoted to the post of Deputy Commissioner of Taxes, Government of Assam, and to correct, and a further direction to correct the final relation list, the cadre of Deputy Commissioner of Taxes for the year 2020, and place the petitioner above the private respondent, and further not to promote the private respondent to the post of Joint Commissioner. Stop. The present writ petition, in the same writ petition, the pleadings were exchanged during the pendency of the writ petition. It is submitted to the court that both the petitioner and the private respondents stood promoted to the next higher post of Joint Commissioner of Taxes. Under such circumstances,
My promotion.
huh?
I was not promoted. My promotion was
Only
he was
recommended.
promoted. Only recommendation was my.
Sorry, the private respondent was recommended for promotion, and which led to the writ petitioner filing the subsequent writ petition, being WBC so and so, challenging the minutes recommending promotion of the private respondent in the roster point reserved for STP. Stop. In WPC 4319, while issuing notice on 4/9/2021, was provided that the promotion to the post of promotion of the private respondent number 7 would not be made without leave of the court. This is promotion to which post?
Deputy Commissioner of Justice.
Deputy Commissioner. You are still not Deputy Commissioner.
No, my lord, joint commission. They are
What
not
are you
picked.
saying?
Yes, they are not picked.
2021, that promotion was still.
4319 of 21, there is an interim order.
But the
To the
interim
effect
order
that the
was-
private
yes.
respondent 7 would
Next
not
level.
be made, would not be given promotion with the leave of the court. Promotion to which post?
DCT. No, Joint Commission.
Joint commission.
Yes, sir.
From DCT.
No. Joint Commission.
Stop.
Yeah.
Notwithstanding this interim order, according to the writ petition, the minutes of the meeting were held, and by recommendation of the
Minus dated
of the DPC dated 4/2/2023, the private respondent was recommended for promotion of JCT, Joint Commissioner of Taxes, Government of Assam. And as a consequence thereof, WPC so and so of 2021 was filed. Wherein, while issuing notice by order dated
27/6/23.
27/6/2023, this court had directed that promotion of the private respondent 7 within bracket to the post of JCT pursuant to the recommendations of the DPC so and so bracket close shall not be notified till the returnable date. The said interim order has been extended and is subsisting till today. So, during the course of the hearing of the matter, it has been submitted at the bar that the writ petitioner as also the private respondent has the writ petitioner has by subsequent recommendation of the DPC stood promoted to the post of JCT.
My lord, to that effect, I filed the addition.
To which the said fact is brought by way of an additional affidavit already connected to the records. So, Learned State Counsel for the petitioner also submits that the seniority in respect vis-a-vis the petitioner and the private respondent number 7 stood restored in the feeder category of DCT, whereby the petitioner was then placed above the private respondent number 7. So, the only issue now be considered in WPC
3565.
3565 of 2023
Yes, ma'am.
is the interstate seniority between the petitioner and the respondent number 7 in the cadre of JCT. stop. Although the recommendation in favor of the respondent number 7 was earlier, has been challenged in the present writ petition. Since the writ petitioner has, in the meantime, also been promoted to the post of GCT, the question now would be the inter se seniority between the petitioner and the respondent number 7. Under such circumstances, this court considers it appropriate to vacate the interim order which was operating against the private respondent number 7. The state respondents are at liberty to notify the promotion granted to the writ petitioner by the communication dated so and so by the DPC minutes held on so and so date. Stop. This although the interim order is vacated, the question of the inter se seniority between the petitioner and the respondent in the post of JCT, if required, with reference to the feeder post of DCT, would remain open to be decided in the final hearing of the matter. What about further promotion?
It will be the additional commissioner tax.
Is it in the pipelines?
My lord, if he is given the
Then
promotion
not
from
yes.
23, my lord, he will be senior again.
No, seniority will be decided by the honorable court later, my lord, in this writ petition itself. Only, my lord, since the post is there, we want the officer, lordship will allow.
It is made clear that in the event the state proceeds to undertake further promotion to the next higher post of additional commissioner, no final decision be taken without leave of the court during the pendency of the writ petition. So far as
no final decision in respect of the writ petitioner, private respondent, if it only comes within the zone of consider, that may be state. Otherwise, some other person.
No, not the others. With
Yes,
regard
only
to the
private respondent.
with regard to the private respondent number
Yes.
7.
My lord, additional commissioner post is 2. So that's all. Those
Oh.
are already filled up.
They are already filled up. That view of the matter, WPC number 4319 of 2021 stands disposed of without any further orders. Stop. Same be segregated from WPC number 3565 of 2023. The WPC 3565 be listed for hearing in the month of July. The part 2 hearing list.
Small correction, not even mentioned as writ petitioner instead of the private respondent.
Pending I is in this writ petition number 9. 4319 are also dismissed. Interim orders stand vacated. Yes.
The lordship is recorded as writ petitioner instead of the private respondent while vacating the interim part.
The
Subject to
promotion, the subsequent higher post of additional commissioner in respect of the private respondent, if undertaken by the department, final order be passed without legal.
Public. Can it be in the date fixed and
lordship will keep it without seniority remains. Otherwise,
no partner.
Otherwise, let it be on part 1 list. Otherwise, it will not be listed.
No, it will be listed because you see the problem is because of all the admission hearings, we are unable to touch the hearings. Either we'll have to
my fear, my lord.
either we'll have to upgrade these hearings to admission, or we'll have to find out a way because
Or a date may be fixed for part one.
you make a mention before the court, matter will be listed accordingly. You let it be in the part 2 hearing list. Make a mention, remind the court that this was heard on so and so date. We take it up.
Okay.
Apply. Yes.
Yes, the residence authority departments are directed to furnish certain records of the last 2021 for 2026.
Yes,
Publicated
PHE,
in
who's
the
for PHE?
PhD department. And Mr. Borua, AG office. And there is an interim order that was the amount provisional pension that was your lordship was pleased to pass an order that is also not yet released. I have submitted my representation. In compliance with the order, they should have released.
What is the challenge here?
My lord, the story is like this, my lord. This person was an engineer with a PhD. Then some charges were put on him. Then he comes to court. The honorable court passes a direction that you complete the DP, conclude the DP, calculate his annulments, what he gets, allowances, whatever it's his dues. Then we do that. Then the DP is concluded. His services, whatever his benefits flown from there, my lord, he files a contempt case. He takes the money from us. And now, in spite of everything said and done, my lord, now he comes and challenges that very DP. He says that DP was fallacious. DP was not up to the DP doesn't. Then he is asking for now promotions also. But in the meantime, his PPO has been issued. PPO is also there.
Where is that order of the content?
Annexure to measure. There's 96 months. 96 to 99.
'97 when it starts.
97. My lord, here the reading of the relevant portion, my lord, here. As it was an entitlement of the petitioner evaluated by the respondents regarding the amount to be paid, we direct that the balance amount of rupees 51,000. That, in respect of the requirement to bring the inquiry proceedings to its end, it is stated that the inquiry proceeding resulted in a requirement of the respondent authorities to pay the petitioner an amount of rupees 7,29,697. Out of that, for some reason, rupees 51,000 was deducted. It is stated that the said amount is in respect of the pending salaries that were due to the petitioner. It is stated that out of the said amount, an amount of rupees 6,78,245 had already been paid to the petitioner, except for the amount of rupees 51,452. As it was an entitlement of the petitioner evaluated by the respondents regarding the amount to be paid, we direct that the balance amount of rupees 51,000 be also paid to the petitioner immediately. Accordingly, we are of the view that the requirements of the order 12/6/2017 had been complied with in the aforesaid circumstances. However, the petitioner raises an issue that the amount he is entitled would be more than rupees 7,29,697 and Mr.
Where is the inquiry report?
Inquiry report, my lord, Annexure 3, my lord. Page number 100 to 110, my lord. This is an expert inquiry report, my lord. Not in compliance with the first judgment, they could not complete within the outer limit of 3 months. And ultimately, an expert inquiry report without the date on which it was prepared also, that inquiry report has been furnished to me after about more than 8 months from the date of judgment. From the date of judgment.
And in the meantime, he retires, my lords.
In the meantime, I have been retired, my lord. And before that, my lord, I have filed the contempt case for willful and deliberate violation of the first judgment and order.
Now against this, you are furnished with a copy of the inquiry report.
Without any, after passing this inquiry report, my lord, with annexer 4 for the first time in 2018, by the annexer 4, my lord, a forwarding letter by the chief engineer to me.
You were asked to furnish a reply.
Yes, my lord.
You filed your reply?
I have given the reply.
What was the
annexer
decision?
42, my lord.
What was the decision of the disciplinary authority?
Disciplinary inquiry, my lord, here, the relevant portion, just I want to draw the attention of this honorable court. Here, there is fault on the part of the petitioner. I have been deprived from my legitimate right to cross-examine the witnesses because in compliance.
No, this will come to later. What is the finding of the disciplinary authority?
Disciplinary authority, my lord, last. Here, my lord, department 2 was at fault during his last year. Page number 109, my lord. The department is in no way responsible for the disease. See, Roy Chaudhary has been suffering from neither else disease, a rare kind of.
This is the inquiry report.
This is the inquiry report, my lord.
We want to know what order the disciplinary authority was.
Disciplinary authority, my lord, no. They have not furnished this inquiry report to the disciplinary authority. That is the only.
Then who issued the penalty order?
Penalty, there is no penalty, only an amount of ₹7,20,000 has been sanctioned. Annexer 40, as per this inquiry, in order to get relief from the contempt case, my lord.
No, Mr. Counsel. Come to page number 111.
Yes, my lord.
Now, 111 is a letter issued by the chief engineer. Is the disciplinary authority?
Yes,
Yes.
with page 111, annexer 4, my lord.
Yes.
Yes, annexer 4, this is the letter, my lord, along with the inquiry report.
Very nice. Very well. But you have been asked to make a representation within 7 days.
Yes.
You filed your representation.
I have filed.
Now, after that, what happened?
After that, my lord, they remain silent.
They remain silent.
Then remain only hide annexer 48 for the first time in order to get relief with contempt for proceeding, and in order to get for personal appearance, they have sanctioned this amount. Annexer 48, my lord.
No, but you said there is a penalty order.
Penalty, my lord. This amount has been as per the ex parte inquiry report. They have sanctioned this amount, but not as per the ROP rules. I have been deprived from my legitimate right to receive my monthly salary with effect from March 2008 till my retirement, without any salary. But my service was utilized by them. That is my respectful submission before. A so-called notice was issued, my lord, because they have told me that
Where is the penalty order?
My lord, before that, my lord, his penalty, my lord, there was, my lord, kindly come to page 229, 299. 299, my lord, and 300, my lord. The petitioner himself approaches his department and says that give me pension. There is a acquiescence also on his part. He accepts what is this is due, my lord.
You had initiated a departmental proceeding. The inquiry was held. You submitted, you served a report asking him to give a reply. He gives the reply, then what happens?
The petition is so bulky.
No, No consequence order.
No consequential order,
No consequence.
but they have stopped your pension.
No. He
Stop.
retires in the
Only
meantime,
one-
he retires, my lords.
Only one party has been paid, Provident Fund, and recently they have released after
So
filing this.
you are taking the advantage of Rule 21, 22.
22. My lords will kindly come to page 118. It was his total, we found out his annulments.
118.
Then he accepts everything, my lords. Now PPO has pension order has also been issued. Now he comes back. He never agitated this issue. Now he comes back and says, give me promotion. Lordship will kindly peruse the prayers also.
My lord, here it is 18,310. This is the provisional pension in comparison to
We are
contract.
asking you what has happened to the departmental proceedings. Was it taken to its logical end? Yes, Mr. Borua, anything to submit?
My party.
Was there any proposal sent for pension?
No, already sent, we have issued.
Already
the
he has
PPO
issued.
also.
PPO.
PPO issued, my lords.
That is, only last picture was there, we are paying him 18,300, 310
Huh.
rupees. That was also lordship query was that how it will be.
Yeah.
This is the provisional pension, my lord.
There is no provisional pension.
Once the PPO is issued, how can it be
Well,
provisional?
I have 7 this PPO.
Then
While NSR 7 and 8 is in the instant W, the press cause of action error. Because this provisional pension, they are going to fix as a regular monthly pension.
Once a PPO is issued,
Yes, my lord.
there cannot be a provisional pension. It
Yes.
has to be stopped.
Yes.
You may have a grievance that whatever figure was amount was given to you as provisional pension has been treated to be final pension. That is a different issue.
Yes.
But now you are earning pension. You are basically questioning the quantum of pension.
I have paid before this honorable court for arrear salary and also arrear pension with effect from 31st December 2017.
All right.
And also, my lord, the regular monthly pension to be fixed at the rate of 50% of the last basic pay.
That everything
My,
flows from the.
lordship, I want to make it such for a moment. I have calculated properly as per ROP rules whenever they fail to do that, and under table 1, 2, 3, 4, and 5. It will be clear, my lord. On the next that I will make it clear. What amount I am entitled to receive as per the ROP rules. At the last basic pay, 50% should be calculated. But they have calculated provisional pension as my regular monthly pension. How?
My lord.
Then automatically entire further benefits will be decreased, my lord. I have been deprived from my legitimate rights for last 9 years without any pay. When the deputy secretary had given a warning letter, 2 letters, it could have been settled in 2013, my lord. Unnecessarily, the matter has been delayed, my lord.
Yes.
Only one time regarding this query. Once we have issued the PPU, our monthly vision agency under 10 year lordship only one query. Why, how it is been, how 1,1800 money is coming.
No, not that query. We are asking you first what has happened to the departmental proceedings.
Yes.
Is it closed? Is it abandoned or what?
I have to intervention because
nothing.
he is
consequential order. They completely failed.
well, that in that case, my lords, we are wrong also. But that very contempt order which I have shown, my lord, page 97, it settles everything. It is again finality. On basis of that, my lords,
We don't know whether it has
on basis of that calculation, my lords, he comes and hammers us with the contempt and takes the money. Now, after that money he takes, he is stopped from bringing this issue, my lords.
My lord, it
Now,
contempt
if
is-
lordship goes for the prayer portion also, lordship will see what is he asking. Promotion.
2 promotions, I have been deprived. I am in Gedison, my position is number 1, my lord. I stood first position while I was working in this senior
That is
division.
something else, my lords. He's mixed up all prayers, man. Then he
I have been
asks
deprived
for
from my
regularization,
legitimate
my lords,
to
of his
get
leave
2
periods.
promotions.
Then he asks us for GPS, GIS,
But my
whatever.
juniors were promoted, 9 and 10. During there is no inquiry, departmental inquiry. I was allowed to work, but I was not allowed to put signature in attendance register. That is the
We
arbitrary.
come to page number 98.
Page number 90. Page number 90. Yes.
Page
Yes, sir.
number 98. Read the
Yes,
paragraph.
yes, 98, madam.
Please read this paragraph in respect of.
Yes, sir. Verse 90. In respect of the requirement to bring the enquiry proceeding to its end, it is stated that the enquiry proceeding resulted in a requirement of the respondent authorities to pay the petitioner an amount of rupees 7,29,697. Out of that, for some reason, rupees 51,452 was deducted. It is stated that the said amount is in respect of the pending salaries that were due to the petitioners. It is stated that out of the said amount, an amount of rupees 6,78,245 had already been paid to the petitioner, except for the amount of rupees 51,450. As it was an entitlement of the petitioner evaluated by the respondents regarding the amount to be paid, we direct that the balance amount of rupees 51,452 be also paid to the petitioner immediately. Accordingly, we are of the view that the requirement of the order 12/6/2007 has been complied with in the aforesaid circumstances. However, the petitioner raises an issue that the amount he is entitled would be more than rupees 7,29,000.
What is writ petition 744?
My lord, with the same,
My lord,
making some dead person's party, he filed.
My lord, this second WBC case I have filed.
He has withdrawn this, man.
Selling the expert inquiry. And then during the pendency of the second WBC case, these two interim letters had been issued by fixing my regular monthly pension. I have challenged this.
In this page 98, this paragraph, there is a finding by the court
Yes,
that an amount of 729
yes, my lord.
is payable to you, out of which 51,000 is deducted.
Yes, my lord.
So the final direction is that the 51,000 is to be paid.
Yeah, yes,
And the amount of the balance amount had already been paid to you.
No, balance 51,000 was not paid as part out of 7,29,000.
I know.
That's why I have filed a second contempt case, item number 28.
How is the second contempt case maintainable? You come to the second paragraph.
Only for this, but my lord, just I want to know 51,000 they have deducted without assigning any reason.
You have to read the order the way it is.
That is a part of the my area.
Then you come to the paragraph below.
No.
Accordingly, we are of the view that the requirement of order dated has been complied with.
This amount, 7,29,000, has been sanctioned as per the expert inquiry.
He accepted
The expert inquiry report has got no legal validity in the idea. I have challenged this expert inquiry. I am entitled to receive about 1 crore rupees. 1 crore rupees.
Your entitlement has to be brought to its logical end. Merely making submissions before the court that you are entitled to this amount and that amount, it doesn't entitle you to that amount. We have to pass a specific order. In order to pass a specific order, we are trying to understand the sequence of your facts.
Yes, my lord. Your lordship has regarding 7,29,000. They had sanctioned as per 48 annexer abstract. 7,29,000. There is no reason how they have calculated this amount. And this is ROP rule, they have not calculated as per I am entitled to receive from March 2008 to till my retirement, about 9 years salary, a year salary. I was not put under suspension, I was not terminated from service only for 1 year. 1 year absence, I had submitted duly my leave application.
What happened to the 744 writ petition? 744.
Oh, 7, my lord, 7, this is the wrong, the typing mistake. Actually, second, 774. It should be 774. It has been withdrawn, my lord.
Withdrawn because he
with
made
the
some
permission of the
dead
honorable
parties,
court,
dead
because
parties party.
Then you have filed this writ
let me
petition.
sorry, my lord, I had
After
seven,
withdrawing, you have filed this writ petition.
My lord.
my lord, annexer 5, annexer 5 case
right.
112 and 114.
You tell us about the status of the inquiry report.
My lord.
My lord, it's a very serious matter, but they have dragged me in a very
Please don't second for June. By the next date fixed, the council for the, what is this, PHE? Will apprise the court with the status of the inquiry proceedings initiated against the writ petitioner, whether the inquiry proceedings have been concluded by specific orders passed by the disciplinary authority.
Well.
If that be so, same be placed before the court.
Well.
List according. Second,
Your lordship was pleased to give the interim prayer, but I had an interim prayer to release the provisional pension.
it can't be done in view of the PPO being released. PPO is issued, so no provisional pension.
Then it will finally this.
Second.
But again,
Yes, rest of the matters will continue to take dates from the court
but
master.
as a far sighted, the better will be taken, because I will try to make it clear regarding.
Yes, yes.
Item number 29. Item number 29 can it be taken on 4th, my lord?
All right, fourth.
My lord. And my
Fourth.
lordship does not give me indulgence. Can I make one more prayer, my lord?
Yes.
Can this matter be listed at the top of the hearing list, my lord?
Which matter?
This item number 29.
You make a mention on fourth. Remind us.